Honey, we get in and out, in and out, in and out. Ooh, ooh. Ah, man. Oh, man. What's good? What's good? What's good? Hey, Queen, everybody. Can you hear me, honey? Queen, everybody. Girl. I don't know what to say. I just need to know if you can hear me. I will be in, I ain't gonna be in and out, but I got shit. Can you hear me? Or do I have to do my self check? Hold on, I can do my self check. Hold on for a minute. Hey, Courtney, look, can you hear me? Do I have to do myself? I can do my self check. Hold on. I just hear the baby in my arms. In my arms. Okay, yep, I can hear me. So, yeah, we got quite a bit to cover, baby. Quite a bit to cover. And listen, I have no idea why y'all just won't let a sister just be off the grid. Oh my goodness. Y'all, listen. You know, I'm gonna have to give it to you, but y'all won't let a sister take a weeks off or nothing. Boy, I'm up here struggling. Hold on for a minute. Well, oh boy. You know, I took a look at this shit and I said, I'm gonna go last. Oh boy, I'm gonna have to go last, honey. I'm gonna have to go last on this one. Cause how is y'all weekend, honey? How is y'all weekend? Oh, thank you, so sweet. How is y'all weekend? Well, I'm gonna tell you. Shit. I don't know. Can I get these likes at Team Kels from the beginning? Don't get mad at me. Oh, here's the thing, right? Here's the thing. I have not. I just read just the very portion of one of them, but just by me reading that, I had to go find what prompted this morning's drop, right? So once I found that out, I was like, shit, they'll never figure this out. So I can go last, right? I can go last. So I don't know why we all doing this competitive thing, but whatever. But hey, I'll be ready to bust some motherfuckers' ass, baby. How the song go? How my bars go? I'm trying to fuck a nigga lungs up. Davey like, Angie, put those damn guns up. Fuck that. Y'all, so listen. So there's a reason why we do everything, right? When you look at the case, any case that have co-conspirators, Lord, co-defendants, co-conspirators too, same, in this situation. You have to put a lot of work in the books first, right? Because you're leading up to this point. And so that's why I tell y'all get y'all pens and papers and stuff like that, because and I don't mind going over stuff, whatever. That's not it. But I need y'all, like, if whatever you're hearing, well, I don't care where you're hearing it from. I need certain things to jog your memory so you can know, why is this being done? Why is, what does this mean? Whatever. That's why I give it to you ahead of time, right? So remember our earlier. I went over hearsay. We went over severance. We went over cursio. We went over cursio with regards to this situation now. We went over the Crawford, and I touched on Bruton, right? And that's Crawford rule, and that's Bruton rule. There's a reason, because those things come to play when you're dealing with co-defendants, co-conspirators, and things of that nature. So, also, we talked about mandatory law, primary law, secondary law, which is case law, as well as, and these are, and well, let me say this. Now I'm speaking about those things when it comes to a good motion, right? So you got, somebody either side may quote mandatory law, primary law, secondary law, which is case law. They may have some remedies in there. They should have remedies to be a good motion, as well as, if at all possible, evidence to support what they are saying. And they don't need to have it, but it's, you always want your motion to have a fighting chance to get passed, but you don't want to disclose too much, the tip off the other side, right? So this is a lot that it's more that went on than just meets the eye, right? So when I saw this, the government's Santiago Proffer, right? I said, okay, I got to go find out where this come from. And wouldn't you know it, it was prompted by none other than a filing that was dropped on 7/8 by Milton Brown's defender, Mary Judge, who we like, right? She is a defender. We know them as PDs, but they FDs, in this case. And she is putting in her work. Okay, she's putting in the goddamn work. But let me explain some things, right? Before we get into all that reading. Let's get the good parts out the way. First of all, I'm going to start with Milton's first, because it loops into the government's for R. Kelly, right? And so, and I understand it. I think Larry and Dana has already read that, if I'm not mistaken. So, if that's the case, then I'm still gonna have to go through and read it, but I can start here with the Milton Browns on, so I can show you how it makes a correlation to what happens with this this Santiago Proffer, right? And so when the government puts in a Santiago Proffer, it's done to show that R. Kelly participated, right, in the conspiracy, as proved by statements, right? They do this to try to get around issues with hearsay. Okay? This is what the government does. They do this to try to get around issues with hearsay. Now, the defense, maybe J-Bo, I'm not sure, because, you got three. You got three of them on there now, right? And this motion, it's going to apply to three. Everything's going to apply to all three of them, unless it's, sent in by the defense, the individual defense, the individual defense, and then you'll see if one of them tried to adopt it or jump on it or whatever, then you'll see paperwork for that coming through. But when the government is, they are addressing all three defendants, right? So you may see J-Bo come back and say that they should deny this last motion, the Santiago Proffer, because it does somehow violate. Let me see how I can put this. I want to make sure y'all get this. That it does violate the conspiracy exception to the hearsay rule, as well as it may present issues under the confrontation clause. So remember, Crawford and Bruton deals with the confrontation clause. Crawford is the out of court statements that are made, right? And by someone that's not testifying, but it is supposed to be testimonial. And testimonial means that it proves something. And non-testimonial means that it only supports some type of evidence. So you're gonna have to get. I'm gonna try to get it in your head together, because this is what happens when you have codependents. Remember, I told you I don't like this shit, and this is why dealing with hearsay and all of this. This is crazy, because they're gonna be trying to play these little games. Okay, so I'm trying to make it simplified so that you can understand. So you may see Jabo come back and say that, well, it does violate, some type of the conspiratorial exception to the hearsay rule, as well as issues with the confrontation clause. Now, if that's the case, right? And I don't know if this is the case because I haven't read it, but if that's the case, then you can, the government can put in a statement, right, from a co-conspirator. And it could be because there is something called a co-conspirator's hearsay. As long as there is evidence to prove that a conspiracy actually happened. If that's the case, then the judge most likely will grant it, because there's proof that they got the statement, right? That's coming up under conspirator's hearsay, as well as there's proof, right? So from what we know about the case thus far, there is probably some proof that a conspiracy did go down, right? So if that's the case, then they're probably going to grant this motion, but I haven't gotten into it, so I'm not sure. I'm just telling you all the ways. And if that happens, right, if they grant it, then she may come back and say, put a motion in for them to prove that there is additional, and I'm not on screen, y'all, there is additional evidence of this conspiracy. All right, I'm just telling you what may happen. You know how we do. When down the line, this may happen. I'm not saying it's going to happen or that this is the case, because I haven't gotten into it. But this is generally what you see back and forth when it comes to a Santiago Proffer. That's what the defense usually comes back with. Like, hey, they should deny the admitting of this statement under the conspiratorial exception to the hearsay rule, as well as, or it could be a situation with the confrontation clause. And the confrontation clause just means that the accused should be able to address and question and examine the accuser, right? And that happens, and if your co-defendant decides to implicate your ass, but you take the fifth, then there's a violation on the confrontation clause. So it goes. So that's what I was explaining to y'all about a month or so ago, about how this worked, and when I was talking about Crawford, right? So, and the difference. So that's what I'm saying. Just get y'all pen. Y'all have to write this down. But I told y'all write this down before when I was going over it, whatever. Now it done come up. Now we got to go over it again. And some bullshit. So just remember, with Crawford, these are out of state, I'm still out of state, out of court statements, right? And they are offered to for proof of the matter asserted, right, in the statement. The difference between bruiting, that the same still applies, but with bruiting, that bruiting means that the co-defendant is implicating the defendant in the motherfucking statement. So that's the two differences. Everything is still the same, but that's the only two differences. So make sure y'all write this down, because you're going to probably, you might see this. I don't know if, bruiting, I don't know, because I don't know if somebody is going to implicate somebody else, the co-defendant, because you're probably implicating yourself in that type of situation. But you want to make sure you get that, because if not, and if it comes up, you're gonna be confused. Why? You're gonna be asking the question again. Well, how they allowed this? But this is hearsay. This is because with hearsay, it's a whole bunch of exceptions, right? Which a hearsay is allowed, So I don't know what to tell you, but this shit here looks bad. Because I'm gonna tell you now. I didn't. All I got was to the just the little paragraph, because I already know what it's about. This is talking about some statements. So it's somebody saying somebody done something. That's why, So I don't want to seem all over the place, because I am, but I'm kind of taken aback by that, because let me come around the front. Let me come back around here. Kind of taken aback by that. But let me tell you why. Because if you are a Kel supporter, and I'm gonna keep it 100, you got videos, you got motherfuckers taking a stand, you got statements. I'm not sure where the statements are coming from. We don't know that yet. I haven't read it. I don't know if the document would tell us. And under the rules of evidence, most likely that shit would be admitted. With Santiago, you're trying to get this stuff, you're trying to get them not to, the government's trying to get them to admit it. The defense definitely want it out. So if you are a Kel supporter, I'm going to keep it 100 with you. I'm going to keep it 100. You got statements, and you don't know who they from. Now, here's the thing. Those statements, they're not coming from the victim witnesses, because they are already on the stand. So it's not from them. It's for some more people. And it could include the co-defendants, but we do know it's from people outside of the people that's already taken the stand. So that's what I'm saying. It gets worse. So I know I done said a whole bunch of shit that probably went over your head. And I'm gonna go through it as we go. But I just wanted to make sure that y'all, I don't know how some people take notes or whatever, if y'all even want to take notes, but I'm just saying. Once I saw that drop this morning, I said, oh hell no. This is crazy. So please, if you really care about, this man's situation, please leave that damn lady alone. Please leave that lady alone. Because this is like getting shit through and dealing with the rules of evidence. It's not easy. And you need complete motherfucking goddamn focus. Because now you got statements and shit. Some of the and here's the thing, right? You got non-hearsay. You got non-hearsay with exceptions. And you have a statement that's not been offered for the truth of the matter asserted, which is all those three things most likely are admissible. And see, that's confusing in itself. You understand what I'm saying? So it's a bunch of technical shit, and this right now she needs to focus, because I don't know what the fuck is going on. If they done hit them with some statements, and we know that it ain't the people on that most likely it ain't the people on the goddamn stand. Because if it were, we wouldn't need all this. No goddamn Santiago. So it's more shit. So y'all let me know if y'all understand. If y'all lost, because we're gonna go through it. Are y'all lost yet? Have I lost it yet? Because we finna go through it, honey. Ooh. But I got to start with old Mary Brown. I got to see what she put in, because she prompted this. So we got to start there. So let me get to reading. What could have violated? Okay, what could have violated again? Okay. It could violate. Okay, which one you mean? Because I done said a whole bunch of violations, honey. I've been all over the place. Do you want to wait till I go through it like line by line? Because it could violate the confrontation clause. That's the biggest issue. Because when you have statements coming in, that generally means that somebody's ass is not there to testify. And if that's the case, then that's when you see a lot of back and forth, right? And they start talking about Crawford, and then if it's the somebody, if it's one of the co-defendants that's not taking a stand, but that's incriminating somebody, and they start talking about Bruton, and those rules are, so it could violate those rules depending on depending on what the statement is, if if it's admissible or not. So that is why, oh my gosh, that's why I get so aggravated when people start hollering, yelling out the word hearsay. I'm like, that's not what it means. Like, you just mean he say, she say, or rumors. Stick to rumors. Use that word. No. Okay. So no. RL is from what we understand from the last paperwork, she is supposed to be testifying. So it's not coming from her. So, but anyway, let me get into Milton Brown, because this correlates with each other. I had to go find out what prompted this Santiago and shit. But Mary Brown is not Mary Brown. Mary Judge is on her job, honey. I'm sorry, I'm all over the goddamn place. I am rusty, but I get together. Come on. Okay, let me find what I'm looking for. Okay. All right. So this came out on 7/8, right? This is Milton Brown. And that's why I said you got to cover Milton, McDavid. You got to watch Don. He had a lot of stuff going on 6/27. I think his trial into the 2023, I believe. So, we have a moment to catch up on his shit, because I started reading, but went and read the transcripts that dealt with him and Faith and that, and also him calling the goddamn, doing a bomb threat and all that bullshit. So we could pick up with him because we got the basics. All right, now we're back on Milton Brown now. All right, this is Mary still at work. Okay, so now remember, I haven't read this, so I'm just looking at the bold type. So remember Mary had did that wonderful motion in limine, right? Which was so good that Jabo adopted 2 through 5 of it, right? And she jumped on that, right? So the government had responded, right? So this is Mary still fighting for her motion in limine. Okay, she's still fighting. All right, I like Mary. Okay, she good. All right, it says Defendant Milton Brown's response to government's consolidated motions in limine. Defendant Milton Brown, by the Federal Defender Program and its attorney, Mary H. Judge, respectfully submits this consolidated response to the government's consolidated motion in limine, docket 211, and this reply to the government's response to Defendant Milton Brown and Robert Kelly's consolidated motion in limine, docket 228. And both of these documents are filed in time, right? Because they have to, these are pre-trial motions, so they have to be filed during, a specific time, okay? In order, because if something, if the later on, if just say this trial results into a conviction, and if it goes through the post-conviction phase and the appeals process, they will have this already preserved on record, right? Okay, so let's see. It says 1. Government's motion for notice concerning Rule 608B impeachment should be denied. Government motions number 8. So she is countering the government motion number 8, the impeachment, impeachment evidence. All right. In its consolidated motion in limine, the government requested prior notice of Rule 608B, specific instances of conduct, impeachment evidence. Specifically, the government proposed a procedure by which, prior to each cross-examination, defense counsel would have to notify the court and the government of the intent to impeach by specific instances. This request should be denied for 5 main reasons. First and most notably, the government cites no precedent for such a procedure. Moreover, counsel is unaware of any such precedent. So right there, she's saying that they didn't cite mandatory law or primary law, right? No type of something with regards to the Constitution, amendments, anything like that nature, or anything with procedures, right? Which would be primary, okay? Or any such precedent, right? So it could also go down to case law as well. Second, the federal rules of evidence do not contain any provision requiring, encouraging, or even discussing prior notice in this context, let alone the government's proposed procedure. Further, the omission of such provision in Rule 608 is made more conspicuous by the inclusion of comparable provisions in other rules. Go ahead, Mary. Consider, for example, Rule 44B, which requires the government to provide advance notice in a criminal case where it intends to offer evidence of other crimes, wrongs, or acts at trial. Federal Rules of Evidence, Rule 44B3. Notably, the Rule 44B3 requirement applies only to prosecution, not the defense, as the government requests here. Lastly, the motion should be denied for 3 additional reasons. To start sidebars, every time 608B evidence is anticipated on cross-examination would be tedious and disruptive to the defense. They would break the continuity and flow of the trial and needlessly distract any jurors by distancing cross-examination from the information presented during direct examination. Relatedly, the proposed procedure would contrary to Rule 611's guidance, waste time, not save it. Oh, okay, she writes kind of backwards. Okay, let me get used to her writing. Finally, Rule 402, relevance judgments should be made during questioning, and that approach is generally preferred. The government argues that its proposed procedure would reduce the risk of irrelevant questioning by addressing the matter prior to cross-examination. But this would Okay, but this would put the cart before the horse because the information needed to make the relevance determination is itself often gathered during questioning. Thus, there is no reason to believe that the proposed procedure would be fairer or more streamlined than the usual standing objection approach. 2. Government's motion to preclude argument and evidence of selective prosecution theory should be denied in part. Government's motion number 9D. Mr. Brown has no intention of making arguments or introducing evidence of selective prosecution. Of course, such arguments would be improper. That said, the government's motion is impermissibly broad insofar as it would, if granted in whole, preclude admissible evidence. Specifically, Mr. Brown takes issue with the government's request that defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 5, 4, 5, and 6, docket 228 at 33. In elaborating on that request, the government explained that it hoped to preclude the defendants from deflecting blame for their criminal conduct. Okay, so remember when we were going through the government's motion to eliminate, I told you that they were shutting down defenses, right? They were shutting down defenses. And you can actually say, for the most part, the government, when they put in that Santiago motion, they are trying to actually box the defense team in, right? With those statements, trying to get them in. They're trying to, they're showing where there is no reason for the judge not to allow these statements to come in. And I'm pretty sure when we read that document, that word hearsay is going to be all up and through it. But I can't wait to see what J-Bo says. If she responds to it, I can't wait to see what she says, because they are trying to what I noticed what they're doing, what Chicago is doing. They got a sense of how J-Bo pencil whipped that paperwork. They trying to box her in, stop her, block her, shut her down. And that's fair game. That's what you're supposed to do. But I mean, they doing it real hard. What I'm trying to say, at every turn, they are just shutting it down. Like, God damn. So with Lennon Weber, and I'm not taking nothing from him, but he is up in age. I wonder if he'll be able to, let me see, if he'll be able to get through it to come to a fair resolve, right, for both sides. Because you don't want to see viable defenses just shut down, and and then that's probably going to result in definitely going to result in a goddamn a guilty verdict, and then you got to see how it play out in the next phases, right? So, now I'm not saying that they have anything on their defenses that should be allowed, because I can't say that, because I don't have the file. I'm just deciphering what we see or whatever. But I'm not questioning him. Well, I guess I am, but I just want to know, will he be able to catch it? If there's something, because as y'all recall, they pretty much, I don't know what defense they had left, but to show up and say, hey, I'm signing in, I'm on record for the defense, and just stand there because you ain't got shit to present. Hell, to me, if he shut all that shit down, hell, all they doing is just gonna show the fuck up. Hell, god damn, and take lunch. The fuck? Anyway, let's go. says evidence and arguments regarding the parents of minor one are relevant for other proper purposes. Evidence and arguments regarding the parents of minor one are relevant for other proper purposes. Consider, for example, the role of minor one's parents in her continuing contact with Kelly. Go ahead on Mary. Mary is in her shit. Wait a minute now. Evidence of their knowing participation in an encouragement of that relationship would, for instance, go to Mr. Brown's belief that either, number one, minor one's relationship with Kelly was not sexual, or number two, minor one was old enough to participate in a sexual relationship with Kelly. The use of such evidence in this way would not raise the issue of selective prosecution. Thus, Mr. Brown asked that the court grant the government's motion in part and deny it to the extent that it would preclude otherwise admissible evidence of minor parents' conduct. Okay, so not saying that's her defense strategy, right, for minor number one, but this is a strategy that's aiming straight for the goddamn jury. Okay, it's not really addressing the tapes and all that type of stuff, whatever. She is finding a crafty way to raise reasonable doubt. So this is a play for reasonable doubt. Just say if those two examples she raised in that what I just read, this would be a play for reasonable doubt. You got to watch how they move, okay? You have to watch how they move. Now, with the tapes and shit and the people on that point talking about they in the tapes and whatever, I think it's gonna be another situation where they not fucking with that evidence. They just gonna try to go for reasonable doubt. So in this trial, you may hear more about the parents' roles, or where were the parents and shit like that. You might, if that's allowed, depending on its relevance, you may hear that shit. But right now, I don't think they fucking with them tapes. Let's keep reading. Number 3, government's motion to preclude argument of evidence of non-pertinent traits of defendant's character. Sorry, I can't see. Government motion number 12, an argument that Mr. Brown may offer only limited reputation evidence under Rule 405A. In Mr. Brown's consolidated motion in limine docket number 213, counsel argued that the court should permit Mr. Brown to introduce evidence of his law-abiding character by reputation, opinion, and specific acts. In its consolidated motion in limine and its response, the government makes 2 contentions with regard to that request. First, the government moves to preclude argument or evidence of non-pertinent character traits, docket 211 at 35. Second, the government contends that Mr. Brown may offer limited reputation evidence for being a law-abiding citizen under Rule 405A. As reference. As for specific instances of that character, however, the government argues that Mr. Brown may not introduce such evidence. Starting with government's motion number 12, Mr. Brown agrees so long as evidence of his law-abiding character is permitted as a pertinent trait. In section 7 of its response, the government concedes that reputation or opinion evidence of such a character trait would be permitted at least under Rule 405A. The only disagreement here is to whether Mr. Brown may also prove that character trait by means of specific instances under Rule 405B, which provides that where a defendant's character is an essential element of a charge, claim, or defense, the character or trait may also be proven by relevant specific instances of the person's conduct. Turning now to the government's argument that Mr. Brown may not admit evidence of specific instances of his law-abiding character, Mr. Brown asked the court to grant his motion number 1 in whole. The government contends that Mr. Brown may not introduce specific instances of Brown following the law on other occasions as character evidence. In support of that argument, the government cites two cases, and there's a case law. Both of these cases, however, are inopposite and inapplicable. In Reese, the defendant sought to elicit evidence of his failure to engage in unlawful conduct during his cross-examination of a co-conspirator who cooperated and testified for the government. Reference. There, the issues presented by the exclusion were hearsay. Oh, Lord. Rule 106 recordings and the confrontation clause. Oh, gosh. Not once in this part of the decision, i.e., B, the district court did not abuse its discretion by excluding recorded conversations between Reese and Rasmansanta. Did the court discuss character evidence generally or Rule 405 specifically? In Hearsay, the defendant sought to discover evidence that he never engaged in previous misconduct while working for the Illinois Secretary of State to support his entrapment defense. The Hearsay quote provided by the government comes from an irrelevant passage in which the Seventh Circuit affirms the district court's refusal to compel discovery of records from the federal and state investigation into the matter. Moreover, when distinguishing, I'm sorry, y'all, I can't see today, distinguishing United States versus Sternstein, the Second Circuit in 1979 holding that the defendant was entitled to discovery of records reflecting hundreds of properly fixed tax returns in tax fraud case. The Hearsay court even implied that there are indeed cases where such evidence is discoverable and admissible. Hearsay 900, Federal 2nd at 1163, 5. Since this motion does not involve discovery obligations, hearsay, Rule 106, or the Confrontation Clause, Reese and Hearsay are in inopposite and inapplicable. Okay, so she's saying right there that the government, see, that this is going to get crazy, that the government used case law that, and remember, it doesn't have, it's not going to be like all the elements are going to match. No. It has to be like the factors and circumstances and things of that nature. And that's when that determines if you're using the correct case law. So she's saying that since that the case law that the government used did not have anything to do with discovery obligations, hearsay, Rule 106, or the Confrontation Clause, then it shouldn't have been, used or applicable when making a decision. So she's telling the judge, you can't use what the government submitted in making a decision with regards to Mr. Brown being able to use whatever evidence he wants to use with regards to his character. So that is what she's saying there. Now, if that's the truth, I think the judge should rule in her favor on that. Because you're comparing something that you really can't compare. That type of case law to this situation. You can't really do that if those factors are not present. So I don't know. We'll see. Number 4, Mr. Brown's motion to preclude evidence that Mr. Brown made travel arrangements for minors 4 and 6 should be granted. Mr. Brown. Okay, hold on. All right, y'all, give me 1 minute. I got to get something to drink. Because I know what my problem is. I haven't drank my soda, honey. Give me 1 minute. I'll be right back. Oh, God. Oh, shit. Ooh. Oh, I'm back. Wait a minute. Let me put this in the refrigerator right here. Whew. Okay. Take a swig. I'll get to it. Shouldn't take that long. Let me see. All right. Hey, y'all just coming in. All right. Now let's read this. In his consolidated motion in limine, docket number 213, Mr. Brown moved to bar the government from eliciting testimony from minors 4 and 6 regarding the times Mr. Brown made hotel reservations and travel arrangements for them as inadmissible Rule 404B evidence, presumably conceding that the proffered evidence, and proffered evidence, this simply means that it's evidence that submit offered to prove something. All right, that's what it means. Where was I? Okay, presumably conceded that the proffered evidence is inadmissible propensity evidence. The government instead argues that such evidence would constitute direct evidence of the charged offense. The government misstated and misapplied the law on this matter. This evidence is absolutely not direct evidence of the charged offense. Knowingly receiving child pornography, namely a recording allegedly portraying minor 1 engaging in sexual acts on videos 2, 3, and 4, and instead is evidence of other bad acts. Huh? Evidence of other bad acts. Well, y'all can check this for me. I don't know. But is there a charge for videos 2, 3, and 4? Is there a separate charge? Or does those videos show up in with the conspiracy? You know, she might have something. As discussed in his motion, this testimony would be irrelevant to count 6. Oh. You know what? Okay, let me switch hats. We're doing Milton. So she might have something. Because if it was a charge with if this was R. Kelly's paperwork, then I would say, nah, this week. But since this is Milton, video 2, well, she might be wrong still, because if he had anything to do with the recoupment of videos 2, 3, and 4, then it might not be additional evidence. And I'm sorry, y'all. I'm tired and I don't feel like pulling up that goddamn indictment. So we'll just have to table that. Let me see. Okay, so it says, as discussed in this motion, this testimony would be irrelevant to count 6. More importantly, the testimony involved minors other than minor 1, the only minor alleged to have been depicted in videos 2, 3, and 4. Additionally, the travel and hotel arrangements were made years before the conduct at issue in count 6. She might have something. I like old Mary Judge. She might have something. Notably, the government hints in its response that the testimony may be relevant to the allegations against Mr. Brown in count 6 because count 6 partly incorporates count 5, which briefly mentions but does not otherwise substantially involve minors 4 and 6. Reference. specifically because Mr. Brown is supposedly included in the and others language of the conspiracy count. Okay, the government argues that the hotel and the travel arrangements provided for minors 4 and 6 are admissible. So I was right. So they're saying, so she might lose this because it is dealing with the recoupment of the bill, the conspiracy part. You understand what I'm saying? So in this, she might lose this because those videos are, I guess, are a part of that. So she may lose this. Okay, let me see. Although not spelled out in the government's response, the argument would depend on the contention that the government can prove what is alleged in the indictment. In this way, the government offers another attempt at admitting this testimony against Mr. Brown as standard direct evidence as opposed to Rule 44B evidence by casting a lifeline out to count 5. The attempt to use count 5 to get this evidence in against Mr. Brown should be rejected for 2 reasons. First, with respect to Mr. Brown, the travel arrangements are irrelevant to count 5. That count mentions Mr. Brown, minor 4, and minor 6 only 3 times in total. One in part 1C and mentions, one in part 1C, it mentions that Kelly employed Mr. Brown from 1997 to 2019. Reference 2 in parts 1F and 1H, it mentions that minor 4 met Kelly in 1999 when she was 16 years old, and minor 6 met Kelly in 1997 and 1998 when she was 13 or 14 years old. 3 in parts 1J and 1K, it mentions that Kelly engaged in sexual acts with minors 4 and 6, and that Kelly recorded himself engaging in those acts with minor 4, among others, not including minor 6. Nowhere else does count 5 mention Mr. Brown directly or minus 4 or 6 directly or indirectly. Now, this sounds like Debo had something to do with this. Remember me talking about R. Kelly wasn't mentioned until page such and such. Let's see. Indeed, in terms of the alleged conduct underlining the charged offense of conspiracy in that count, minors 4 and 6 are not discussed at all. None of the overt acts have anything to do with either minor. Second, and more importantly, the incorporated language from count 5 is surplusage to count 6 with respect to Mr. Brown. That is, nothing in the incorporated language is necessary to determine Mr. Brown's guilt or innocence as to count 6. The incorporated language, especially parts 1F, H, J, and K, is of no consequence to count 6 allegations that Mr. Brown helped Kelly retrieve the videos of minor 1. As surplus evidence that the government argues supports that count 5 language, but which, as discussed above, indeed irrelevant to even that count, is irrelevant to count 6. Thus, the government's attempt to pad their argument by reference to count 5 is unavailing and should be rejected. What? Okay. But you're trying to make it specific to the actual minors. But if it's specific to the tapes, the recoupment of the tapes, then that's I don't know. Y'all write that down. Let's see if they come back and say it has something to do with the tapes and not who's on, who's exactly on them. Let's go. Again, it is worth noting that beyond the relevant issues discussed above, if considered Rule 44B evidence, the testimony still constitutes improper propensity evidence if offered against Mr. Brown. That argument is provided in Section 2, Part A, subsection 2 of the motion. Reference. In short, Mr. Brown outlined possible chains of reasoning that the government might offer and noted that Rule 44B requires the proponent to show how the evidence is relevant without relying on a propensity inference. Okay, yeah. Importantly, the government does not cite any case law to challenge Mr. Brown's framing of the Gomez analysis, and it does not contend that it is not relying on a propensity inference. Indeed, the government goes so far as to offer one of the very propensity-dependent chains of reasoning that Mr. Brown cautioned against in his motion. Reference. Specifically, the government makes the following argument. Premise 1, Brown's knowledge that minor 1 is depicted in videos 2, 3, and 4 is essential and relevant to count 6. Conclusion. Accordingly, Brown's knowledge of Kelly's involvement with minors is probative of Brown's knowledge of what was depicted on videos 2, 3, and 4. Docket 228 at 3 and 4 summed up, the government wants the jury to believe that since Mr. Brown allegedly helped Kelly have sex with minors 4 and 6, Mr. Brown should have also known that a minor was likely depicted on the videos at issue in count 6. So remember, I told you when she first put in her motion, and I think it was motion in limine, that I could tell that she was trying to go with the defense that you can't say that Mr. Brown went out there to recoup these tapes and get them off the streets because he had no knowledge of what was on them, and he don't know how the girls are. He don't know shit. He don't know nothing about nothing. So if he don't know, how can you prove intent? How can you prove that that's why he went out there to recoup the videos? What may happen with that defense is then he may be an issue. Now something may become antagonistic to R. Kelly's defense because then they may ask them, why did he go out there and get the videos and shit? And if that's the case, then he might have to say somebody told him to go get it. Well, who was that somebody? So, I don't know. Hey, this one day, babe, I'll probably be hollering, I don't know. I don't know where we're going. I don't know about this. Well, let's go. Obviously, that argument relies on an unstated premise. In order for the conclusion to logically follow, that missing premise that must be some form of the following. Because Mr. Brown helped Kelly engage in sexual activity with minors 4 and 6. Because Mr. Brown helped Kelly engage in sexual activity with minor 4 and 6, it is more likely that Mr. Brown knew or should have known that the relevant tapes as charged in count 6 depicted a minor, i.e. minor 1. Okay, so when she say helped engage, she's probably referring to they saying that he made travel arrangements and all of that, thereby helping him engage into having some type of sex with these people. Nothing else would connect Mr. Brown's action in making hotel and travel arrangements. Damn, if I kept reading the shit, I would have got to it. Nothing else would connect Mr. Brown's actions in making hotel and travel arrangements with the knowledge that specific tapes at issue in count 6 depicted minors, not only would that constitute a propensity inference and thereby violate Rule 404, because so remember, you can't, they don't allow propensity evidence, right? Only in certain case instances where to prove like something like motive or something like that, but not, just as evidence to prove someone's guilt. No, they don't allow that. It would also constitute a compounded propensity inference whereby Mr. Brown propensity to assist Kelly is layered up top of Kelly's propensity to engage in sexual activity with minors. See docket 213 at 7, outlining 4 of the propensity inferences relied on by the government. Thus, the government has not and cannot identify a propensity-free chain of reasoning to satisfy Rule 404B. Remember, if it's ruled as propensity evidence, which means its evidence shows that somebody is most likely to do something, you can't, that evidence is inadmissible unless it shows someone that, their intent or something like that, right? It just can't be admitted just to show somebody's propensity to do something, right? So, but you know what? The government might come back and say, well, it's not propensity because to their knowledge, this is Mr. Brown's only such violation. So, I don't know. They could word it up a certain way like that. You understand what I'm saying? So there shouldn't be a chain of propensity evidence like he's behaved like this in the past over and over again, which means that he's most likely committed this crime. If this is his one and only, situation like this, I don't know what's in his criminal history or anything like that, but they could come back with something like that. Let me see. As for the government's request to admit this evidence against Mr. Brown, co-defendants, Mr. Brown offers 2 possible responses. One, should the court allow this testimony against co-defendants Kelly or McDavid or both as direct evidence of counts 1, 5, and 7, 13, Mr. Brown would need to be severed. Oh, okay. Look at Miss Judge. She is pushing the severed button, honey. Yes, look at her. Okay, let me see. Where's she going with this? Alternatively, Mr. Brown asks that if this testimony is allowed, the witnesses refer to him by either a pseudonym or as an unnamed, unidentified employee of Kelly's. This would allow the government to use the testimony to prove the allegations against his co-defendants while avoiding improper uses against Mr. Brown. Oh, okay. I like old Mary. Okay, remember I told you a good, proper motion has remedies and shit in there too, right? Lastly, should the court decide that Rule 404B does not preclude this evidence, Mr. Brown asks that the court preclude the evidence under either Rule 402 or 403. First, the testimony would not be relevant to the charges against Mr. Brown. As defined in Rule 401, evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence. And B, the fact is of consequence in determining the action. For the rules of evidence 401, here the evidence would not satisfy that definition. Most notably, the testimony would not make more or less probable any fact of consequence to the allegations in count 6. That count does not even remotely involve minors 4 or 6. She keeps honing in on these minors 4 or 6. And we got to look at, damn, I don't feel like looking at no goddamn indictment. But is it the minor is in there? Okay, so wait a minute, she might have something. Because if it's depending on how it's listed in the elements, do they have to prove it's minor 4 or 6 and the tapes and all of that? I guess we should look at that. Instead, it involves conduct from August 2001 to April 2007 by Mr. Brown, Kelly McDavid, Individual A, Individual B, and unnamed others to retrieve tapes depicting Kelly and Minor 1. Okay, so she is harping on what I'm saying. She's trying to get ahead of what I keep saying that the government may come back with. That it's not about the minor, it's about the tapes, right? So I guess we do got to look at that goddamn indictment, but it won't be tonight. So notably, the testimony by minors 4 and 6 refer to actions taken long before that time frame. Second, if the testimony has any probative value, it is substantially outweighed by the danger of unfair prejudice, confusing the issues, and misleading the jury. Federal Rules of Evidence 403. This is a complex case with more than a dozen counts, some of which directly involve minors 4 and 6. Allowing the government to elicit this testimony would risk confusing the issues as to the counts and misleading the jury as to the potential scope of Mr. Brown's criminal liability. Additionally, this testimony would create a risk of unfair prejudice, as Mr. Brown could be held accountable for actions unrelated to the alleged conduct for which he is charged. Conclusions for the above reasons, Mr. Brown asks that the court grant his motions in limine and deny in whole or in part the government's motions in limine 8, 9D, and 12. Okay, so damn, she good. I like old sister girl. Let me get this other one up. I'm coming on right now. I'm coming on around in a minute. I am tired. Oh my God. So listen, y'all. Listen. Did anybody get that what's the name? That spam and shit. So listen. I like O'Mara. So y'all see what she's trying to do. So let me come back around and check on y'all. So I know I read that kind of choppy, I just read the first reaction. But listen, these ladies are putting in work. They are definitely putting in damn work. Okay. I don't know what to say though. Because here's the thing. She keeps trying to lessen his criminal liability because she keeps pointing at the minors, which is got something to do with the tapes. Now, do that mean I got to pull up that? Let me pull it up. I'm gonna get to this one, but let me just pull that other one real quick, because I don't like to leave no live with nothing on the table. Let me see. I should have got me some more rest. I was going off on a goddamn message board, but I definitely worked through the night trying to get this shit out of the way. I'm behind. Let me see. I just want to know if she got a shot at it in hell. Because she did a lot of fancy work, honey. I mean, it's hard to get a complete picture of this shit without pulling out all the parts, doing all the fucking parts, and going back and referencing all other paperwork. So shout out to the people that can remember this shit, cause I can't. Okay. 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 So let me pull up this indictment. 1 minute, y'all. I got to. Okay, so he's in count. What's that count? 5? No. Wait a minute. Hold on. Count 5. Okay, from Milton Brown. Hold on, where is he now? Hold on. He in count 6. Shit. Okay. Okay, here you go in count 6. Count 6, it says that defendants herein did knowingly conspire with each other, individual A, B, and others, known and unknown to the grand jurors, to receive child pornography as defined in Title 18 U.S.C. blah blah blah, namely video 2, 3, and 4. That has been mailed and shipped blah blah blah. She ain't gonna win this. Well, that's decided. It has not, Miss Mary, baby, it has nothing to do with the minors. It has something to do with them tapes. The goddamn tapes. And his, so y'all remember he's on count 6. On here it has it just has something to do with your the conspiracy. It doesn't even name a minor on here. So yeah, as I thought. So y'all see how we resolved that particular motion with that little part right there? She's stuck on trying to make it about the minors when it's about the tapes with regards to him and the recoupment of it. So now they probably gonna come back and say what I'm saying. Ain't got nothing to do with the minors with regards to that part, because they're not saying he actively had any type of sex with them or whatever. And as far as him making the travel arrangements and things of that nature, whatever, they are just using that. The government, from what I can understand, they're just using that to show that he had knowledge of who he was booking, how they were, and all of that. That's what they're using that for as a part of their evidence with regards to him. So, yeah. Yes, ma'am. Thank y'all for coming on through. Make sure y'all hit that button. So y'all understood that. So Star, you got that. Y'all, rest of y'all got it. So y'all understand how we resolved that particular motion that she put in, that response in a way. She's trying to make it about the girls, and I can see them right now. I think Leonard Webber, with his old ass, he'll catch that. He'll catch that. So let me start reading this long ass document. Okay. So we are on the government's Santiago Proffer and motion to admit evidence pursuant to Federal Rules of Evidence 801D2E. Okay. Now, Santiago Proffer of evidence is evidence to prove something, right? This has something to do with some type of statements, out of court statements. So let's get into this, see what it says. It says the United States of America, by its attorney, John R. Launch Jr., United States Attorney for the Northern District of Illinois, moves to admit certain statements against defendants Robert Sylvester Kelly, Darrell McDavid, and Milton Brown, pursuant to Federal Rule of Evidence 104A and 801D2E and United States versus Santiago. Okay, reference. It says, introduction. The defendants are charged with participating in conspiracies involving obstruction of justice and the receipt of child pornography in the form of video recordings. In this submission, the government provides an overview of the charged conspiracies that will be established at trial, describes the law governing the admissibility of conspiratory statements, and outlines some of its evidence establishing the charged conspiracies. Based on the following, the government seeks admission of statements pursuant to Rules 801D2E and requests a pretrial ruling of admissibility from the court in accord with United States versus Santiago. And actually, you know what, y'all? I left something out. Hold on. Sorry, wait a minute. It wasn't that motion I just read that prompted this motion. It was the one that was filed on 7/6. I'm sorry, the one that was filed by Miss Judge on 7/6 that prompted this. Her motion on 7/6 deals with all those the statements and things of that nature. I had already read this motion, but that's the motion that deals with that. So I just want to make sure, just for references, if anybody want to tie the two together. So it's the one that was put in for Milton Brown on 7/6, that Milton Brown consolidated motions and limiting. All right. It's document number 227. Okay. So let me take it from the, what was it? Okay, based on the following, the government seeks admission of statements pursuant to Rule 801D2E and requests a pretrial ruling of admissibility from the court in accord with United States versus Santiago, 582 Federal 2nd, 1128, and it says 7th Circuit, 1978, and established practice in this circuit. See United States versus Alvear. Oh, goddamn, United States versus Harris. Okay. This submission does not detail all the government's evidence that will go to show the existence of the charged conspiracies or all of the co-conspirator statements that were made in furtherance of the charged conspiracies. Oh, wow. So we may see, okay, I know we're going to see Crawford again. So we may get to see Bruton at some point, because now they're saying are all the co-conspirator statements that were made in furtherance of the charged conspiracies. So one of them made some statements out of court. Okay, let's see. So this is going to be bad. Now you got the co-defendants on record. I mean, not record, but record as far as the statement. Somebody, one of them on record, one of both. All right, let's see. Rather, this submission highlights for the court certain of the government's evidence sufficient to establish the existence of the obstruction of justice conspiracy described in count 5 and the related receipt of child pornography conspiracy described in count 6 and the participation of the co-conspirators. As a result, this submission does not list all the government's evidence and witnesses, nor does it provide all the evidence that would be presented by identified witnesses. Background. Overview of the charge obstruction of justice conspiracy. The superseding indictment alleges that from approximately 1996 to 2001, Kelly engaged in sexual contact and sexual acts with minors, including minor 1, 3, 4, 5, 6, reference 93. As part of this abuse, Kelly recorded himself engaged sexually explicit conduct with minors on videotape. During this time, from approximately 1991 to 2014, Kelly and or one of Kelly's businesses employed McDavid as Kelly's business manager. As a business manager for Kelly, the services McDavid provided to Kelly and for Kelly included protecting Kelly's image, reputation, and assets when victims of Kelly's sexual abuse pursued or were part of a civil action. Whoa. So that's how they're tying, that's one of the ways how they're tying McDavid to those civil actions to R. Kelly, which in a way is showing that McDavid allegedly knew about what was going on, right? This is another way they can blame, the government is blocking a defense if McDavid comes and say, well, I didn't know nothing about what was going on, so how can I be a conspirator, or, you know, because I would have to know that to be a conspirator, I would know that I'm doing something wrong. Well, if McDavid goes with, I'm just working there, I didn't know nothing was going on, I ain't have nothing to do with it, they can use this to show that, yes, you did. And because you were involved in these civil actions. Oh, shit. God damn. Well, I should have read this fucking next year. Shit, fuck this. This is bad. God damn. Count 5 of the superseding indictment charges Kelly and McDavid with conspiracy to obstruct justice relating to child exploitation and child pornography. Reference 93. McDavid and others knew of Kelly's sexual misconduct with minors and knew that Kelly recorded himself engaged in such conduct on videotape, which is what I just said. So they're trying to tie him. Okay. Again, I have to keep repeating this. I want to make sure y'all know this. Chicago, these people here on this case, they are kind of masterful with shutting down a lot of shit. Trying to anyway. They shutting down his defense if he's something that say he ain't know nothing about it. They letting you know in this paperwork. If you come with that bullshit, this is what we gonna say. We're gonna say, yeah, you knew about it. And this is how. It doesn't necessarily mean that it's true, but if his hands are tied to them civil actions and those girls were underage or whatever, or, you know, I don't know if some of them got the herpes through it, whatever. I don't know what the civil lawsuits or the NDAs or whatever constitute. This is saying, yeah, you did know. Damn, they should have took they should have took a plea if they, god damn, the fuck? Shit, I done got shaking. I don't know where the fuck I was. Wait a minute. It's crazy. Okay. McDavid and others knew of Kelly's sexual misconduct with minors, and they knew that Kelly recorded himself engaged in such conduct on videotape. In approximately 2001, Kelly and McDavid learned that multiple such videos were missing from Kelly's collection. including video 2, 3, and 4. After making this discovery, Kelly, McDavid, and others conspired to conceal and cover up evidence, including videos relating to Kelly's sexual with contact and sexual acts with minors. Kelly, McDavid, and others also agreed to intimidate, threaten, and pressure others to falsify and make false entries in records and documents related to Kelly's sexual misconduct with minors. Wait a minute. Okay. Whew. To accomplish this, among other things, Kelly and McDavid agreed to pay others to collect and return incriminating videotapes and to keep silent about Kelly's sexual relationship with minor 1, among others. Further, Kelly paid McDavid to ensure McDavid would continue to conceal and cover up evidence of Kelly's sexual misconduct with minors. Based on these and other facts, Kelly and McDavid are charged with conspiracy to obstruct justice relating to child exploitation and child pornography. Count 5. Overview of the receipt of child pornography conspiracy. Count 6 of the superseding indictment charges Kelly, McDavid, and Brown with conspiracy to receive child pornography, reference 93. Brown, like McDavid, provided services to and for Kelly for years. Count 6 realleges certain paragraphs from Count 5, including those referencing Kelly's sexual conduct and sexual acts with minors, and Kelly's recording of those sexual encounters on video. Kelly, McDavid, Brown knew of Kelly's recorded sexual activity with minors, and when they discovered that certain of the videotapes were missing, they paid others to recover and return certain videotapes. Specifically, between August 2001 and 2007, defendants conspired with each other, individual A, B, and others, to receive videos 2, 3, and 4. Argument. 1. Governing law. Okay. So this is where they probably got some mandatory primary law stuck in there. Man, probably some case law as well. It says Rule 801D2E provides that a statement is not hearsay if it is offered against a party and is a statement by a co-conspirator of a party during the course and furtherance of the conspiracy. Oh, Lord. So it is one in there about the co-conspirator. Oh, Jesus. Oh, what the rest of this soda? Wait a minute. Oh, God damn. So somebody done said something. Oh. Now, it doesn't mean that he is on a statement telling on R. Kelly or whatever. That doesn't mean that. It could mean that in some type of statement, let me see how to put this. Some type of statement, he may have laid out what happened. Okay. Let's see. Okay. Admission of such co-conspirator statements against a defendant is proper where the government established by preponderance of the evidence that 1, a conspiracy existed, 2, a defendant and the declarant were members of the conspiracy, and 3, the statements were made during the course and in furtherance of the conspiracy. Okay, so the declarant is the person who makes the statement. I'm sorry, I'm just burping. Damn, it's crazy. Oh, case law. Okay, under Santiago, the trial court must preliminarily determine whether statements by a co-conspirator of the defendant will be admissible at trial under Rule 801D2E. In making this determination, the judge must decide if it is more likely than not that the declarant and the defendant were members of a conspiracy when the hearsay statement was made, and that the statement was in furtherance of the conspiracy. And it quotes Santiago. It says, if the court determines that the statement are admissible, the jury/court may consider them for any purpose. Wait a minute. If the court determines that statements are admissible, the jury can consider them for any purpose. Okay, so they're definitely trying to get around all those hearsay exceptions and all of that. Okay, this is what they're trying to do with this. Oh, man. So, A, existence and membership in the conspiracy. In making the initial admissibility determination under the Santiago criteria, a court can consider the statements in question, those to be admitted. See Bonjurli versus United States. While a court may consider the proffered statements themselves as evidence of both the existence of a conspiracy and the defendant's participation in it, the contents of the proffered statements alone are not sufficient to establish the existence of a conspiracy and a defendant's participation. Reference and case law. Instead, there must also be some supporting evidence of fact corroborating the existence of the conspiracy and the defendant's participation in the conspiracy. So remember earlier, when I probably lost y'all, remember I said, there is something called a conspirator's exception, right? That allows a conspiracy hearsay. As long as there's evidence along with that proves that a conspiracy existed, right? So that is what they're saying here. God damn. Why I picked the night to read this? Jesus. Okay. The evidence showing the existence of a conspiracy and the defendant's membership in it may be either direct or circumstantial. Case law. There is no requirement for admissibility under Rule 801 D2E that the government establish all elements of a conspiracy charge, such as a meeting of the minds and an overt act. Case law. The government need only to establish the existence of a joint venture for an illegal purpose and participation in the joint venture by the defendant and the maker of the statement at issue, as well as that the statement was in furtherance of the venture. It makes no difference whether the declarant or any other partner in crime could actually be tried, convicted, and punished for the crime of conspiracy. Okay, which is what I just said, what they need to allow these statements. Okay, this is what they're trying to do. They're trying to get these statements in. Although, as discussed above, there is a distinction between conspiracy law and inadmissibility under Rule 801 D2E. Certain principles of general conspiracy law are relevant to the Rule 801 D2E inquiries. For instance, a conspiracy may exist even if a conspirator does not agree to commit or facilitate each and every part of the substantive offense. Case law. The government need not to prove that a defendant knew each and every detail of the conspiracy or played more than a minor role in the conspiracy. Case law. Further, a defendant joins a criminal conspiracy if he agrees with another person to one or more of the common objectives of the conspiracy. Right. It is immaterial whether the defendant knows, has met, or has agreed with every co-conspirator or schemer. Case law. A defendant or other declarant may be found to have participated in a conspiracy even if he joined or terminated his relationship with other conspirators at different times than another defendant or conspirator. Case law. The Seventh Circuit in 2004 held it is irrelevant when the defendant joined the conspiracy so long as he joined it at some point. Finally, the government is neither required to prove the identity of the declarant nor must the declarant's identity be confirmed in the statement itself. Case law. Rather, the government need only prove from the statement, the context, and other evidence that the declarant was in fact a co-conspirator. Wow. So, you know what? This might be, they might also have some statements from who that in some other people that is not listed in this indictment. And that's what it sounds like. It they have some other people as well. God damn, this is crazy. Okay, B, in furtherance of the conspiracy. In determining whether a statement was made in furtherance of the conspiracy, courts evaluate the statement in the context in which it was made and look for a reasonable basis upon which to conclude that the statement furthered the conspiracy. Case law. Under the reasonable basis standard, a statement may be susceptible to alternative interpretations and still be in furtherance of the conspiracy. Reference. The co-conspirators' statement need not have been made exclusively or even preliminarily to further the conspiracy to be admissible under the co-conspirator exception. Courts have found a wide range of statements to satisfy the in furtherance requirement. Case law. In general, a statement that is part of the information flow between conspirators intended to help each perform his role satisfies the in furtherance requirement. Case law. God damn. It says the Second Circuit in 2002. These include statements made. Okay. 1, to conduct or help to conduct the business of the scheme. Case law. 2, to identify other members of the conspiracy and their roles. Case law. 3, to plan or to review a co-conspirator's exploits. Case law. As an assurance that a co-conspirator can be trusted to perform his role. Case law. To inform and update others about the current status of the conspiracy or a conspiracy's progress. Case law. To control damage to an ongoing conspiracy. Case law. To conceal a conspiracy where ongoing concealment is the purpose of the conspiracy. Case law. To reassure or calm the listener regarding the progress or stability of the scheme. Case law. To report conspirators' status and in turn receive assurances of assistance from co-conspirators. Case law. To describe the purpose, method, or criminality of the conspiracy. Case law. To recruit potential co-conspirators. Case law. Finally, it has long been the rule that any statement made by a conspirator during and in furtherance of a conspiracy is admissible against all co-conspirators. Case law. And it says the Seventh Circuit in 2005 held that whether any other conspirator heard or in this instance saw that statement is irrelevant. Agency, not knowledge, is the theory of admissibility. Okay. C. Alternative basis for admissibility. Many statements described herein and sought to be admitted against the defendant are independently admissible and do not require Rule 801D2E analysis. So that's, again, their way of trying to get around this hearsay situation. Because remember, Miss Mary, Milton Brown's attorney, stated that these statements should amount to hearsay. All right, 1. Defendant's own statements. A defendant's own admission are admissible against him pursuant to Federal Rule of Evidence 801D2A without reliance on the co-conspirator statement route. Case law. So wait a minute. Oh, so one of them said he was in it, or something like that. Oh, damn. So they got a statement, maybe a statement from one of the co-defendants, and some statements from some other people that was involved in this. God damn. Shit. Okay, where was I? This shit keeps shaking me up. Okay, Rule 801D2A provides in pertinent part that a statement is not hearsay if the statement is offered against a party and is the party's own statement in either an individual or a representative capacity. Additionally, a defendant's own admissions are relevant to establishing the factual predicates for the admission of co-conspirator statements against him. Number 2, agency statements. Statements made by a party's agent or employee on a matter within the scope of the employment relationship while it existed are admissible against him pursuant to Rule 801D2D. 3, non-hearsay statements, which I told y'all, non-hearsay statements should be admissible. Let's read. The co-conspirator statement rule is not implicated where the relevant verbal declaration is not a statement within the meaning of Rule 801A. That is not an assertion subject to verification. An example would be an order or a suggestion. Case law. This is because a statement is defined as an oral or written assertion or nonverbal conduct of a person if it is intended by the person as an assertion. Federal Rules of Evidence 801A. Thus, a statement which is incapable of verification, such as an order or a mere suggestion, is not hearsay and does not invoke a Rule 801D2E analysis. Additionally, the conspirator statement rule does not apply when a statement is not offered for the truth of the matter asserted and thus not constitute as hearsay as defined by Rule 801C. Accordingly, the statements by alleged conspirators may be admitted, like I said, against a defendant without establishing the factual predicate set forth above when such statements are offered simply to show, for instance, the existence, the illegality, or the nature or scope of the charged conspiracy. Case law. So again, they're saying that these statements are not hearsay. So it should be, I tell you, they should be admissible. And I don't like to speak in absolutes. That's why I say it should be, but most likely it will be admissible. Number 4, statements against penal interest. Under Federal Rules of Evidence 804B3, a hearsay statement is admissible if 1, the declarant is unavailable, 2, the statement was against the declarant's penal interest at the time it was made, and 3, corroborating circumstances exist indicating that the statement is trustworthy. Case law. When determining whether a statement is against penal interest, each portion of a proffered out-of-court statement is examined to determine whether it is subjected the declarant to criminal liability. Case law. A statement may satisfy this requirement if it would be probative at trial, against the declarant. The Seventh Circuit in 1995 held, applying this standard, the Seventh Circuit has held that a declarant's exculpatory statements made to friends and acquaintances about crimes committed by the declarant and his associates are admissible. All right, the Seventh Circuit in 1994 holding that a jailhouse conversation between two co-defendants, which incriminated a third co-defendant, but was also inculpatory, of the first two co-defendants, was admissible against the third co-defendant. Case law. The Seventh Circuit of 1992 affirming the district court's decision to admit a co-defendant's exculpatory statement, which also incriminated the defendant because it was not made in an attempt to curry favor with law enforcement, but was made to an acquaintance. Such statements against penal interests are admissible against non-declarant defendants. Case law. I'm going to check on y'all. Jesus. Oh my gosh, y'all. Y'all, please get that goddamn spam. What the fuck? Hold on, let me make sure. Okay. Let me get back. All right. The evidence demonstrating the existence of the charged conspiracies and defendants' participation in the conspiracies. The government's evidence of the charged conspiracies and the defendants' participation in them consists of, among other things, one, witness testimonies, including from unindicted co-conspirators and Kelly's minor victims; two, videos containing child pornography; three, polygraph examination records; four, travel records; five, bank and business records; and six, false documents created as a result of defendants' intimidation, threats, and pressure to persuade others to conceal and cover up evidence of Kelly's participating in sexual misconduct with minors. A, testimony of minor number 1, 4, and 5. The government anticipates testimony at trial from minor victims referenced in the indictment that Kelly engaged in sexual acts with them when they were under 18 years old. These sexual encounters took place at various times from approximately 1996 to 2001. The evidence will establish that on many occasions, Kelly recorded himself engaging in these sexual encounters. The testimony that the government anticipates that these minors will provide is summarized below. Oh boy. Number one, minor one. Minor one met Kelly around 1997, 1998, when she was about 13 or 14 years old. Kelly began having sex and engaging in sex acts with her at that time. From the beginning, Kelly told minor one that she was not allowed to tell anyone about the sexual activity. Kelly told minor one that if anyone asked about their relationship being sexual, she should completely deny it and act offended that anyone would act such a thing. Now, so let me tell y'all. Remember a long time ago, I told y'all that based on paperwork, whether it be indictments, motions, or whatever, you can tell, one, if this is evidence that somebody is telling a story to some kind of investigator, or two, if the information that they discover was uncovered based on an investigation. This is somebody telling a story. Okay? So what I'm trying to say is that this seems like Let me see. Yeah, it seems like minor one is directly telling his story and not like somebody is telling it for her. So, 1 minute, y'all. Give me 1 minute. Okay, sorry about that, y'all. And I had to cut this damn fan off. This is getting crazy. Okay. So, okay, where were we? Okay, they engaged in sex hundreds of times in many different places, including his homes, recording studios, tour buses, and hotels. Kelly instructed minor one how to have sex with him and with other girls and women, including individual D, at the same time. Kelly continued to engage in sexual acts with minor one through and after she turned 18. When minor one and Kelly engaged in sex acts, Kelly often recorded them, including by using camcorder with VHS tapes. Kelly kept his video camera and the VHS tapes with the recordings in his gym bag and on a shelf at his house, hidden behind other tapes. So let me tell you this, right? Now, they have the tapes, right? We see they have the tapes. If you're worrying about technology and all that, about the VHS tapes, whatever, don't even worry about that, because they have devices, right? Which includes, they still have a VCR back there in the government. Okay, they could play it on there or what have you, but the defense will examine the actual tapes. They will have their experts examine the actual tapes. Okay. If they need a copy of it, it will go to by protective order, and most likely will show up on a DVD. It doesn't mean that there's evidence was tampered with or none of that foolishness. That just means that they're not going to give you the actual tape, because that's the evidence. They're going to give you a copy of it. They're not going to copy it over on another VHS tape. They give them a copy of it, it's going to be on whatever they're using now. Thumb drive, DVD, whatever. Doesn't mean that the evidence is being tampered with. I cannot. Let's see. Kelly sometimes played tapes depicting pornography while he and minor one engaged in sex acts. Some of these tapes were of minor one and Kelly, and some depicted Kelly having sex with other people. Kelly took the gym bag with the tapes almost everywhere he went and only let certain people he trusted carry the bag. Brown was one of those people whom Kelly trusted to carry the bag. Uh-oh. Oh, Lord, Milton, they done put you in it. According to minor one, Brown knew that Kelly was having sex with minor one when she was under 18 years old. Uh-oh, Ms. Mary, I think your shit is gonna be. Okay, video one, video two, and video three contain footage of minor one and Kelly engaging in sexual activity at Kelly's house on West George Street in Chicago when she was under 18 years old. In video one, minor one is wearing a distinctive necklace. Minor one's passport at the time contained a photo of minor one wearing the same necklace. Oh, minor one discussed the passport photograph with Kelly, his lawyers, and McDavid because it showed her wearing the same necklace visible in video one. Kelly or one of his lawyers took the necklace from minor one. Huh? A lawyer took the necklace from minor one. Oh, wait a minute. Additionally, Kelly created other videos depicting him and minor one engaging in sexual activity together, as well as with other girls, including minor 5, 6, and individual D, all while minor one was under 18 years old. In or about 2000, when minor one was about 15 or 16 years old, government agencies began investigating allegations that Kelly was sexually abusing minor one. Kelly instructed minor one on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago Police Department questioned minor one about sexual contact with Kelly. During the CPD interview, minor one followed Kelly's instructions and falsely denied the allegations of Kelly's sexual misconduct. CPD documented that information in a report. Around late 2001 or early 2002, when minor one was 17 years old, her family members learned about video one, and some of them saw the videotape. Minor one continued to deny the sexual aspects of her relationship with Kelly to family and friends. However, McDavid set up a meeting at a hotel with minor one, her parents, Kelly, and McDavid. During the meeting, minor one revealed to her parents that Kelly and minor one had been engaging in sex acts when she was a minor. All right, so they just destroyed the I didn't know the girls were that age or he was having sex, they was on the tapes or whatever. So they just destroyed that defense for Brown and McDavid. So they just destroyed this based on this. Okay. Let's see where. Okay. All right. Minor one revealed to her parents that Kelly and minor one had been engaging in sex acts when she was a minor. Kelly told minor one and her parents that they were either with him or against him, which minor one interpreted to mean that if they all denied the allegation regarding Kelly engaging in sex with minor one when she was underage, she wouldn't have to worry about what could happen to her family. Shortly after the meeting at the hotel, during the time the law enforcement was investigating video one, Kelly sent minor one and her parents to the Bahamas and to Mexico for several weeks to get away from everyone who was asking questions about video one, including law enforcement. When minor one and her parents returned to the Chicago area, Kelly isolated minor one and placed her in various hotels. Minor one was not allowed to talk to anyone other than Kelly and his associates, and her phone calls were monitored. This continued until minor one and her family agreed to support Kelly and deny to law enforcement that it was minor one on the video. On video one, Kelly was very rich and powerful at this time in his career, and his implied threats of either being with him or against him scared minor one's family very much. Oh, okay, that's the out they gave him. During the state's investigation, minor one and her parents were subpoenaed to testify before the state's grand jury. Kelly sent one of his lawyers to sit in the grand jury room when they testified. Whoa. Minor one and her parents knew that the attorney was there to report back what they said. Each of them falsely testified that minor one was not the girl in video one. Minor one had conversations with McDavid about Kelly having sex with her. McDavid was present when Kelly's team strategized about what to do with video one and its depictions of Kelly engaged in sexual activity with minor one. Minor one will also describe McDavid's participation in what to do with the necklace and its depiction in both video one and minor one's passport photo. In 2008, just prior to and during the state court trial involving video one, Kelly isolated minor one from her family and friends and controlled her movements and contacts with others. Kelly's lawyers prepared minor one on what to say if she was called as a witness. Ultimately, minor one did not testify at the trial, and the jury acquitted Kelly. Minor one, who was over 18 years old at the time of the trial, continued to have a relationship with Kelly after the trial concluded. The relationship was sexual in nature and abusive. Minor 1 ended her relationship with Kelly in approximately 2010, but she continued to have contact with him from time to time after that date. In approximately 2014, for example, Minor 1 asked Kelly for help with rent payments. At first, Kelly refused. Minor 1 reminded Kelly who she was, all all that she had given up from him, and what she knew about their sexual history together. Kelly thereafter made monthly payments to Minor 1 by check between 2014 and 15. Some of the checks said settlement on them, even though Minor 1 never had a settlement agreement with Kelly. I thought they said she had a settlement. I thought they said she had a settlement. Okay, Minor 4. Kelly engaged in a sexual relationship with Minor 4 from 1999 to 2001, when Minor 4 was 16 to 18 years old. These sexual encounters occurred numerous times. Okay, all right, so I see now they remember I said I didn't like if for the prosecution. I didn't like the the time span unless you know you pin it down to actual year or time or something. Because if you allege to have evidence proving that something happened at a specific time or whatever, you damn sure better have that, the actual dates. Not that the dates have to be, but at least the not the year and the day and the month, but the year and the age gotta be, it can't be one or the other, got to be. So I see what they're doing now. So they're saying I was from 1999 to 2001 when Minor 4 was from 16 to 18 years old. So now we can understand. All right. So these sexual encounters occurred numerous times and in numerous locations, including Kelly's recording studio in Chicago and hotels. Once when Minor 4 was 16 years old, Brown told Minor 4 that Kelly wanted Minor 4 to get a hotel room and wait there for Kelly. Brown wanted Minor 4 to reserve the hotel room herself. Minor 4 told Brown that she could not because she was only 16 years old. Minor 4 got the hotel room key by picking up at Kelly's recording studio. According to Minor 4, Kelly recorded himself engaging in sex acts with her, and on at least one occasion, Kelly recorded himself having sex with Minor 1 and Minor 4 together. Number 3, Minor 5. In 1998, when Minor 5 was approximately 14 or 15 years old, Kelly engaged in sex acts with her. Kelly had threatened Minor 5 that he would tell her mother she kissed a boy. Minor 5 felt both fear of and loyalty of Kelly after their first sexual encounter. Kelly told Minor 5 that they all had secrets now. After their first sexual encounter. After the first sexual encounter and continue until Minor 5 was 17 years old, Kelly engaged in sexual acts with Minor 5 together with Minor 1 at least 100 times. These sexual encounters took place at Kelly's home, his recording studio, his tour bus, and hotels. These encounters involved Kelly and Minor 5 alone, Minor 5 and Minor 1 together, or Minor 5 and other girls under the age of 18, including Minor 6. Kelly often videotaped himself engaging in sexual acts with Minor 5 and Minor 5 with others, including Minor 1 and Minor 6. Minor 5 saw video cameras and tripods everywhere at Kelly's George Street house, at his recording studio, and on tour bus. Minor 5 was aware of a false wall in a room in the George Street house that led to a room full of videotapes. Kelly also kept videotapes in his gym bag. In late 2001, CPD interviewed Minor 5 and her mother and showed them still images from video 1. Minor 5 identified Minor 1 in the video as Minor 1. Minor 5 then received a subpoena to testify In the state grand jury, minor 1 told Kelly about the subpoena. Kelly told minor 5 that the police were making him out to be the bad guy and that she should say that it was not minor 1 in the video. 1. Minor 5 testified truthfully in the grand jury that she recognized minor 1 in the photographs that the prosecutor showed her, but she also falsely testified that she did not know of any sexual relationship between Kelly and minor 1. Minor 5 met with Kelly and minor 1 during Kelly's 2008 state trial. Kelly discussed the possibility of minor 1 having to testify. Kelly explained to minor 1 and minor 5 that they could beat a polygraph examination by believing the lie being told because there was nothing wrong with the sexual activity they engaged in when the girls were under 18 years old. Kelly encouraged minor 1 to try and convince minor 5 to deny that it was minor 1 on the tape, to deny that the three had sexual experiences together. Oh, hold on for a minute, y'all. Now I blow my nose. Still blowing my nose, y'all. Give me a minute. Okay. Whew. All right. B. Testimony of unindicted co-conspirators named in the superseding indictment. Yeah. More people. The government anticipates that individual B, C, and D will testify at trial regarding their participation in the charged conspiracies. The testimony that the government anticipates from these individuals are summarized below. Individual B. Individual B met Kelly in the 1990s. Individual B did some concert promotional work for Kelly and some work while Kelly was on tour. Individual B also managed a music group signed to Kelly's record label, and as a result, individual B spoke with Kelly, McDavid, and Brown about various matters related to the group. In approximately 2001, when individual B was living in Kansas City, Kelly called individual B and told him that Kelly needed something recovered and that he would pay individual B to do it. Later, McDavid and individual A private investigator working on behalf of Kelly, called individual B and explained that they needed individual B to recover some videotapes for Kelly and would pay him a reasonable amount to do so. Shortly thereafter, McDavid and individual A met with individual B at a hotel in Kansas City, where they informed individual B that individual D stole a videotape or videotapes from Kelly and that Kelly wanted them back. Individual B agreed to help Kelly recover the property. Under the agreement, individual B was to recover one tape from individual D in return for $100,000, and individual B was to recover one tape that individual D had stolen but did not have any more in return for $1 million. What? Damn. Individual B later entered into a written contract with individual A, who acted on Kelly's behalf concerning the recovery of the individual D videotape that was no longer in her possession. The contract was titled Agreement and Reward for Expenses. The contract listed $100,000 plus expenses as fee to be paid to individual B, even though the previous agreement was for $1 million. McDavid was present when individual B signed the contract. Individual A and McDavid explained that the contract was for a lesser amount to avoid raising suspicion. The conditions for payment required individual B to pass a polygraph examination that individual B knew of no other copies of the videotape. Individual B learned from individual D that she gave a videotape that depicted Kelly having sex with a young girl to a man in Georgia. Individual B provided individual A with the man's name, and in return, individual A gave individual B the man's address. Individual B drove down to Georgia and recovered from the address individual A gave him a videotape that depicted Kelly engaged in sex acts with a young girl. Individual B made several copies of the videotape. Individual B watched the tape and he observed two scenes of Kelly engaged in sexual activity with minor one. The first scene depicted Kelly and minor one engaging in sexual activity on a black and white checkered floor. The video referred to in count 2, video 2. The second scene depicted Kelly and minor one engaging in sexual activity in a bedroom. The video referred to in count 3, video 3. Individual B returned to Kansas City and met with individual A and McDavid at a hotel. There was a polygraph examiner with individual A and McDavid at the meeting. Individual B gave McDavid and individual A only one of the copies of the videotape that individual B recovered from Georgia and retained the other copies. The videotape individual B obtained in Georgia did not contain a separate video of Kelly. Individual D and minor one engaged in sexual activity. The video referred to in count 4, video 4. Individual B asked for payment. The request was refused, and individual B was accused of making copies of the video and keeping the copies. Individual B admitted that he made copies but refused to submit to a polygraph examination. The meeting became contentious. McDavid and individual A told individual B that he could get in trouble for possessing child pornography and accused him of trying to extort Kelly. Individual B remarked that Kelly could go down for having sex with young girls. Well, damn. Kelly called individual B after the meeting. Kelly asked individual B to smooth things over with McDavid and individual A, and he would get paid. Individual B traveled to Chicago to meet with Kelly, McDavid, and Brown at Kelly's recording studio. Ooh, they timed together. Kelly questioned individual B regarding the videotape that he recovered and told individual B that Kelly's life was on the line because he was being investigated for a sexual interest in underage girls. Individual B agreed to turn over another copy of the tape he recovered, but did not tell Kelly that he had even additional copies of the video. Kelly said that McDavid would give him some money as a show of good faith. McDavid gave individual B $10,000 in cash before individual B returned to Kansas City. Oh, let me take a drink. Ooh. Individual B met individual B met individual A and McDavid again in Kansas City and it's submitted to a polygraph examination. The examiner asked individual B whether he made additional copies of the videotape. Individual B said no. The polygraph examiner determined that individual B passed the polygraph examination, even though individual B had in fact made additional copies of the videotape. Individual B nonetheless turned over another copy of the videotape he recovered in Georgia, and McDavid and or individual A gave individual B $75,000 in cash. Over the next years, until approximately 2008, individual B received large sums of money every year or every other year as payments toward the $1 million he was owed. Individual B never received the full amount. In approximately mid to late 2002, individual B met with Kelly and Brown at Kelly's home in Olympia Fields. Brown placed a videotape in a VCR, and together they watched a scene which showed Kelly, individual D, and minor 1 engaged in sexual activity. The video referred to in count 4, video 4. Kelly asked individual B the location of the copy of the videotape that contained that footage, since the videotape that individual B recovered from Georgia did not contain this scene. Individual B returned to Kansas City and spoke with individual C about this missing scene. Individual C told individual B that he had a copy of a tape with video 4, and that he knew he could receive money if he returned the tape to Kelly. Individual C showed individual B the videotape with this footage, and individual B recorded some of it on his cell phone. Damn. At some point in the lead up period to Kelly's 2008 state court trial regarding minor 1 and video 1, individual B met with Kelly McDavid at Kelly's home in Olympia Fields. Individual B denied having any copies of tapes depicting Kelly engaged in sex acts. Kelly told individual B that he, individual B, would be dead if another tape of Kelly engaging in sex acts with the minor surfaced. Kelly further stated that minor 1 and her family would not testify against him because he relocated minor 1 and paid off her family. Kelly expressed concern about individual B disclosing information about the tapes. The following day, individual B met with McDavid, who gave individual B approximately $100,000. God damn. Now they got somebody saying that he did pay him off and stuff like that. God damn. During Kelly's trial in approximately June 2008, individual B contacted news media outlets and advised that he was holding a press conference about Kelly. Individual B wanted Kelly to pay the balance of the $1 million owed to him, and he wanted Kelly and his team to know that he was willing to disclose what he knew about the videotapes containing Kelly engaged in sexual acts with minor 1. Their arranged agreement about the recovery of the tapes. Later that day, Kelly asked individual B not to hold a press conference. That night, Brown gave individual B approximately $10,000 to $20,000 in cash. The next day, individual B met with McDavid, who paid individual B approximately $130,000 to $140,000 in cash. Wow. Individual B then canceled the press conference. Wow. Individual D. Individual D met Kelly in late 1997 or early 1998 in Georgia. They began a sexual relationship and short their time thereafter. Kelly liked to videotape them having sex. Kelly convinced individual D to have threesomes with him and other girls and women. Individual D engaged in sexual acts with Kelly and minor 1 on at least 3 occasions when minor 1 was under 16 years old. The first time occurred in a room in the lower level of Kelly's residence on George Street. I never even heard of George Street as far as R. Kelly's address. Kelly set up a camera before the 3 of them began to engage in sex acts. Individual D engaged in threesomes with Kelly and minor 1 in other places, including on the basketball court in the George Street residence and in a trailer each time Kelly filmed the encounter. Kelly kept a duffel bag with him wherever he went. Individual D looked inside the bag and saw that it was full of VHS tapes. In approximately 2001, Individual D searched through the bag of tapes until she found one that contained footage of Kelly, minor one, herself engaging in a threesome. The tape had 3 different sex scenes on it. The first depicted Kelly and minor one in a room with a black and white chess or checkerboard pattern on the floor, video 2. The second depicted Kelly and minor one in a bedroom, video 3. The third depicted Kelly, minor one, and individual D having sex in a room with wood walls on the lower level of Kelly's George Street residence, video 4. Shortly after taking the tape, individual D gave it to individual C, who lived in Kansas City. Later, individual D moved to Georgia, where she remained in contact with Kelly through 2007. In early 2007, individual D learned that individual C still had the videotape containing video 2, video 3, and video 4. Individual D knew by this point that a different videotape of Kelly engaged in sex acts with minor one, video 1, had been leaked to the public. When individual D was concerned that the tape with her engaging in sex acts with minor one and Kelly would also be leaked to the public. Individual D reached out to Kelly about the videotape through an acquaintance. Kelly flew individual D to Chicago to meet at his home in Olympia Fields. During the meeting, Kelly asked individual D questions about the videotape and offered her $250,000 to recover it from individual C. Kelly said that individual D could divvy up that money. However, she needed to get the tape back. Kelly further stated that McDavid would handle all of the arrangements. After the meeting, individual D contacted individual C. Individual C agreed to fly to Chicago and return the tape. Brown met individual C when individual C arrived in Chicago. Oh, they done tied him all to this, y'all. Brown drove the three of them, Brown, individual C, and individual D, to an attorney's office on Jackson Street near the federal courthouse in Chicago. Individual D and individual C met with McDavid in an attorney's office. McDavid and individual D watched the tape containing video 2, 3, and 4, according to individual D. McDavid was most interested in the parts that showed minor one and the multiple references on the tapes to minor one's 14-year-old body parts. Oh, McDavid kept the video. McDavid asked individual D and individual C about whether there were other copies of the tape. McDavid then took individual D to a polygraph test in that same building. The polygrapher asked individual D questions about to whom she had given the tape and if any copies of the tape had been made. Individual D passed the polygraph examination. Individual D learned that individual C took a similar examination but failed because, as individual D understood it, individual C had made a copy of the tape before traveling to Chicago. After the examinations, McDavid gave individual D and individual C $20,000 each in cash. McDavid stated that they would each receive an additional 80 grand when they returned with the copy of the tape individual C made. McDavid said he would pay individual D the remaining $50,000 of the $25,000 Kelly promised after Kelly's state trial. Later in 2007, individual D and individual C returned to Chicago where they met with McDavid again. Individual C brought with him another copy of video 2, video 3, and video 4 and gave it to McDavid. Individual D and individual C each took polygraph examinations and they each passed the examinations. McDavid gave individual C $80,000, but only gave individual D 50 grand in cash. McDavid said that it McDavid said that if it wasn't for individual D, they would have not had to pay individual C 100 grand. Individual D returned to Chicago a third time. Individual D took a third polygraph examination. During this visit, individual D was questioned about matters unrelated to the videotape. The polygraph examiner determined that individual D failed the polygraph examination. McDavid accused individual D of being disloyal and threatened her. McDavid ultimately gave individual D the $30,000. McDavid told individual D that she would have to talk to a lawyer and deny ever having sex with minor one. McDavid waited in the hallway while individual D spoke to a lawyer who later turned over a summary of the interview to Kelly, attorneys at the time. During the interview with the lawyer, individual D falsely denied ever having sex with minor one. Ooh, y'all, just one moment. Let me get another drink. Let me go out and let me see if I can do something like this spam. Wait a minute while I'm on hold, y'all. Sorry about that. Hold on. Naked. All right, let me see if that helps with the spam. Oh, okay. Let me get back to reading. All right, individual C. Between 2000 and 2004, individual C received a VHS tape from individual D via mail service. Individual C watched the tape. The tape depicted Kelly engaged in sex acts with individual D and a young girl. In around 2007, either McDavid or Brown contacted individual C and explained that they had information that individual C had a copy of a videotape that they were trying to recover, and that they wanted him to travel to Chicago to and return it in exchange for money from Kelly. Brown later followed up with individual C to make travel arrangements for the trip to Chicago. Individual C showed individual B the videotape before going to Chicago and asked individual B for his advice about whether he should go to Chicago. Individual C made a copy of a portion of the tape and took the copy, that is, the shorter version, to Chicago. Individual C met with McDavid, Brown, and individual D when individual C arrived in Chicago. Individual C gave the tape to McDavid and Brown. McDavid, Brown, and individual D went into separate rooms with the tape. McDavid returned and said what individual C gave them was not the original version of the tape. McDavid stated that individual C would have to take a polygraph examination. During the examination, the polygrapher asked questions regarding copies of the videotape. The polygraph examiner determined that individual C failed the examination. Individual C admitted that he kept a full copy of the tape in Kansas City. McDavid instructed individual C to return to Kansas and retrieve the original videotape. According to individual C, McDavid gave individual C approximately $200,000 in cash to show how serious they were about wanting to get the tapes back. Individual C returned to Chicago within days with the original videotape he received from individual D. Individual C met with McDavid and Brown and turned over the tape. McDavid gave individual C a hug, and Brown said that individual C had a golden egg. Individual C took another polygraph examination where the polygrapher again asked a question about the copies of the videotape. The polygraph examiner determined that individual C passed examination. During the same trip, McDavid gave individual C a bag of cash, which individual C determined contained $80,000. Individual C told McDavid that one day he, individual C, was going to give the money back. McDavid said not to worry about it because Kelly wanted him, individual C, to have the money. Minus one mother. Damn. It just gets worse from here. Minor one's mother is expected to testify that she, along with minor one and her husband, minor one's father, met Kelly through minor one's mother, sister, minor one's aunt. This first meeting took place in approximately 1997 and 1998. I guess they're talking about Sparkle, when minor one was in junior high school. The sister, minor one's aunt, was a professional singer. Yeah, I guess it is Sparkle. And she often took minor one to Kelly's recording studio when she was working on music. The sister was in a romantic relationship with Kelly at the time. Huh? Ooh. Sparkle, you done lied. Okay, let's get to it. We ain't mind our own business, child. Around this time, minor one's father, who was a professional guitar player, began doing some work for Kelly as a part-time musician. Sometime after minor one's introduction to Kelly's, minor one told her parents that Kelly was going to be minor one's godfather. Minor one's mother found this strange because minor one already had godparents who were chosen by minor one's parents. After that, however, minor one continued to see Kelly and Kelly's family. The sister was with minor one at times, but at other times minor one went by herself. Minor one's mother understood that minor one was spending time with her godparents, Kelly and his wife and family. In or around 2000, the Illinois Department of Children and Family Services contacted minors one mother and her husband about allegations that Kelly was having sexual contact with minor one. Minor one's mother and father confronted minor one about the allegations, and minor one denied them. In approximately December 2001, the sister contacted minor one's parents and told them that she had a copy or had seen a copy of a tape that depicted Kelly engaged in sexual acts with minor one. Minor one's father told minor one's mother that they had to meet with Kelly. Minor one's mother and minor one's father met with Kelly and McDavid at a hotel. During this meeting, Kelly said he was sorry. Kelly did not state that he had sexual contact with minor one. Kelly said that minor one and her family needed to leave town right away. Kelly and McDavid said at one point, "You're with us or you're not." Kelly also said, "You're with me or against me," and that some harm would come to the family if they decided to go against him. Minor one's mother and father was frightened. Minor one's mother did not want to go up against Kelly's power, money, and influence by not following what he said, and so they decided to go along with Kelly's demand and leave town. After the meeting, minor one started acting differently. Minor one threatened to harm herself if her parents did not go along with whatever Kelly told them to do, that is, to deny that minor one was depicted on the tape. Minor one and her parents left town and traveled to the Bahamas and Cancun, Mexico for several weeks. Minor one's family did not pay for the trip. During their time away, minor one was in contact with Kelly, and minor one's father told her that he was in contact with McDavid. Minor one's mother, minor one's father, and minor one's family discussed and agreed to do whatever Kelly and McDavid told them to do regarding the tapes. Later, after the family returned to the United States, minor one and her parents received subpoenas to testify in the state grand jury. Minor one's mother met with an attorney that her husband said was hired by Kelly and McDavid. That attorney sat in on the testimony of minor one's mother, and minor one's father when they testified before the state grand jury. Minor one's mother and minor one's father had agreed before testifying in the grand jury that they would go along with Kelly and deny that it was minor one in the tape if asked. Minor one's mother was shown a tape depicting Kelly engaged in sex acts with minor one during her grand jury appearance, and she was asked if she knew the individual depicted. Minor one's mother falsely testified that she did not know who the girl in the tape was. Other witness testimony. Polygrapher 1. Polygrapher 1 is expected to testify that in or around August 2001, he received a call from individual A about conducting a polygraph examination of an individual at a location in Kansas City. Individual A described his client as an individual in the entertainment industry from Chicago who was interested in finding out if there was any copies of certain videotapes. Polygrapher 1 understood his assignment to be testing individual B about whether he made any copies of the tape. Polygrapher 1 presented individual B with an examination permission release form. Individual B refused to sign it or provide his name and instead gave Polygrapher 1 a nickname that Polygrapher 1 wrote on the form. Damn, this is getting crazy. Polygrapher 1 discussed with individual A and individual B the subject to be discussed during the examination before the examination began. They agreed that the focus of the examination would be about the performance tape. Polygrapher 1 wrote this title on the form along with the date, August 23, 2001. Polygrapher 1 listed the completed time on the bottom of the form. These notations may mean that polygrapher 1 did not end up actually administering the polygraph examination, or that he perhaps started the examination but ended it early if individual B became non-compliant. Polygrapher number 2. Polygrapher number 2 is expected to testify that in or around spring or summer 2000 or the summer 2001, an attorney with a client in the entertainment business hired him. The attorney told polygrapher number 2 that his client made a tape of him, the client, having sex with his babysitter. Polygrapher number 2's assignment was to determine if the subject of the examination, whom polygrapher number 2 understood to be the person who recovered the sex tape, made any copies of the tape. The attorney told polygrapher number 2 that he wanted to know the results right away, because if the subject passed the test, the subject would receive money. The subject of the polygraph examination was individual B. During the examination, individual B pulled a VHS tape from inside his pants that polygrapher number 2 understood to be the recovered tape that they were discussing during the examination. Polygrapher number 2 determined that individual B passed the examination. Polygrapher number 3. Polygrapher number 3 is expected to testify that Kelly's attorney hired him to administer several polygraph examinations in March and April 2007. Polygrapher number 3 created documents that reflect the subject of the polygraph examinations, individuals C and D, the questions asked, and his determinations. Polygrapher 3 administered polygraph examinations to individual C on April 17, 2007 at a Western hotel in Chicago, and again on April 20, 2007. Prior to each examination, individual C signed a consent form. During the examination, polygrapher number 3 asked individual C questions about a tape that individual C possessed, which depicted Kelly engaged in sex acts with a girl and individual D. Polygrapher number 3 asked individual C if individual C made copies of the tape. In polygrapher 3's opinion, individual C failed the first examination and passed the second. Polygrapher 3 administered 3 polygraph examinations to individual D, one on March 23, 2007 at his testing lab near the federal courthouse in Chicago, 2 on April 20, 2007 at the Swiss Hotel in Chicago, and number 3 on July 26, 2009 at his testing lab. Individual D signed a consent form before each examination. During the first 2 examinations, the polygrapher 3 asked individual D questions about a tape which depict Kelly, individual D, and a person with minor 1's nickname having sex. Polygrapher 3 determined that individual D passed the examinations. During the 3rd examination, polygrapher 3 asked individual C whether she had more than one conversation with individual B about the tape and about money. Polygrapher 3 determined that individual C failed the examination. Polygraph records. Polygrapher 1 and polygrapher 3 created documents contemporaneous to the examinations they conducted. Those documents included dated and signed consent forms, pre-examinations, interview forms completed by the examiner, and the examiner's note listed the questions asked during the polygraph examinations. Further, at least one polygrapher 3's consent form signed by individual D indicated that she agreed that her polygraph examination results would be released to Kelly's attorneys at the time. E. Records from individuals A's business. As noted above, individual A, on behalf of Kelly and in concert with McDavid, facilitate recovery and return of videotapes depicting Kelly engaged in sexual acts with minor 1. Individual A owned and operated a business. Billing records from individual A's company revealed the following entries, which aligned with individual B's testimony about his travel between Kansas City and Chicago and dealings with McDavid and individual A related to the recovery and return of the sex tapes. August 13, 2021, 10 a.m. to 11 p.m., travel to Kansas City, Missouri. August 13, 2001, 11 p.m. to 12 a.m., conference at our hotel with individual KW. August 14, 2001, 1:30 to 3 o'clock a.m., conference at our hotel with individual B. August 14, 2001 to 10,000 to from 10 o'clock, to 11:20 a.m., conference with individual KW, call from individual B to individual KW. August 14, 2001, 3:30 to 8:30 p.m., return travel Kansas City to San Francisco. August 21st, 2001, from 2 o'clock to 5 o'clock, consultations on preparations of reward and expense agreement, telephone conference regarding individual B, extortion with McDavid, and an individual conference call with individual B. August 22nd, 2001, 9 o'clock a.m. to 12 p.m., conference calls with McDavid regarding funding, conference calls with polygraphers, regarding testing arrangements. August 22nd, 23rd, 2001, from 10:30 p.m. to 6 a.m., travel, SF to Chicago. August 23rd, 2001, 9 a.m. to 10 p.m., obtained funding from bank, travel from Chicago to Kansas City, Missouri, conference with individual B, conference with polygrapher number 2, PSE examiner, and with polygrapher number 1, polygraph examiner, administration of PSE and polygraph test to individuals B, further conference with individual B. August 24th, 2001, to 12 o'clock to 2 a.m., telephone conference with client. August 24th, 2001, 10 a.m. to 6 p.m., conferences with individual B and with client, return travel with Kansas City to San Francisco. Individuals A business records also include unsigned and signed versions of the agreement for reward and expenses, contracts with individual B, as well as memos to file documenting individual A's interactions with individual B and polygraphers 1 and 2. Video 1, 2, 3. As noted above, minor 1 is expected to testify that she and Kelly are depicted in video 1, 2, and 3, engaging in sexually explicit conduct. Law enforcement officers reviewed the videos and determined that they depict child pornography. So remember when Mary Judge wanted the testimony as from the cops to be deemed as expert testimony. Remember, I said most likely she's just trying to get them not to testify. Where remember the government came back and said no, they're testifying because they were part of the investigation. Remember, I said they had to, they would be okay to testify if they was a part of the investigation, and they don't have to testify as experts. Okay, so this is what this is in as it relates to what she raised in her motion. Let's see. It says G, false documents and entries created as a result of defendants' intimidation, threats, and pressure. 1. CPD reports of minor 1's interview. Minor 1 is expected to testify that Kelly began having sexual contact with her beginning around 1997 or 1998 when minor 1 was 13 or 14 years old, when minor 1 was about 15 or 16 years old, or about 2000. Certain government agencies began investigating allegations that Kelly was sexually abusing minor 1. Kelly instructed minor 1 on how to act and what to say if she was questioned. In or about December 2000, law enforcement officers from the Chicago Police Department questioned minor one about sexual contact with Kelly. During the interview with CPD, minor one falsely denied the allegations of Kelly's sexual misconduct, and CPD documented that information in a police report. In summary, the police report states that law enforcement interviewed minor one, who stated that she had never been sexually abused by Kelly and that any such allegations are untrue. 2. Minor one, minor one's parents, and minor five state grand jury transcripts. During the state's investigation leading up to Kelly's 2002 state charges related to video one, minor one, her parents, and minor two testified before the state's grand jury. Minor one and her parents testified falsely about whether video one depicted minor one. Minor five was untruthful about the fact that minor one and Kelly had a sexual relationship with minor one was under 18 years old. Those false statements appear in their respective grand jury transcripts. Oh wow. 3. Memorandum of Individual D's interview. As set forth above, Individual D is expected to testify that following her third polygraph examination on or about July 26, 2017, McDavid told her to meet with other lawyers and tell them that she never had sex with minor one. McDavid waited in the hallway as Individual D went in the room to meet with the lawyers and provide the false statements McDavid instructed her to provide. The attorney prepared a memorandum of interview dated July 26, 2007, documenting Individual D's false statements. In summary, the memorandum states that Individual D provided the following information. Individual D knew minor one and had spoken to her on numerous occasions. Individual D never saw Kelly in a sexual situation with minor one. Minor one was never a participant in any sexual encounter with Individual D and Kelly. Individual D agreed to be interviewed by attorneys on July 26, 2007. Individual D was not forced, threatened, or promised anything to participate in this interview. Individual D is expected to testify that the underlying information above is false and that she provided the false information at McDavid's direction. Oh boy. Travel and credit card records. Records from this Atlantis resort in the Bahamas show that minor one and her parents stayed there on February 2002. This was shortly after minor one's parents became aware of the tape and their meeting with Kelly and McDavid, and which the family was told to leave town. Additionally, travel records from Customs and Border Patrol revealed that minor one and her parents re-entered the United States from Nassau, Bahamas on February 9, 2002, and that they re-entered the United States from Cancun, Mexico on February 23, 2002. CBP records also show Brown returning from Nassau, Bahamas on February 1, 2002, and then from Cancun, Mexico on February 21st, 2022. Lord have mercy, Brown. They done, Brown, Lord, they got you going in and out with them. Woo. God damn. A representative from a travel agency is expected to testify about records related to Kelly and his companies, including Bass Productions. Those records include credit card authorization forms, which document reservations that Kelly-related company made for individual C and individual D to travel to Chicago to meet with Kelly, McDavid, and Brown, and to take polygraph examinations, including the following. A. March 23rd to 26th, 2007, Madison, Illinois, hotel reservation for individual D, the date of her first polygraph examination. And April 16th to 18th, 2007, Western Chicago River North hotel reservation for Brown for 1 suite and 3 rooms in individual C's first polygraph examination was on April 17, 2007 at the Westin. And April 19th to 21st, 2007, Omni Chicago Hotel reservation for 2 rooms for individual C and individual D. Both were in Chicago for polygraph examinations on April 20th, 2007. And April 19th to 21st, 2007, Swiss Hotel, Chicago Hotel reservation for Brown, individual D. Second polygraph examination was on April 20th, 2007 at the Swiss Hotel, and a July 25th to 26th, 2007 West Chicago Hotel reservation for Brown. Individual D's third polygraph examination was on July 26, 2007. Credit card records for accounts belonging to the same travel agency show the following charges. Western Hotel River charges on April 19 to 17 through 19, 2007. Individual C's first polygraph examination was on April 17, 2007 at the Westin. Now, y'all see how they keep populating Brown's name all through this? So if I would have read this first, I would have known that this motion was generated based on something Brown had put in, right? But anyway. Airline ticket purchase for individual C for travel from Kansas City to Chicago on April 19, 2007. Individual C's second polygraph examination was on April 20, 2007, and Omni Hotel charges with arrival and departure dates between April 19, 2007 and April 21, 2007. The travel agency reserved rooms for individual C and individual D at this hotel during this time. Additionally, credit card records for accounts McDavid showed the following charges. Omni Hotel charges with arrival and departure dates between April 19, 2007 and April 21, 2007. The travel agency reserved rooms for individual C and D at this hotel during this time. Swiss Hotel Chicago charges with arrival and departure dates of April 19, 2007 and April 23, 2007. Individual D's second polygraph examination was on April 20, 2007 at the Swiss Hotel, and West Chicago Lakeshore charges on July 26, 2007. The travel agency reserved room for Brown for a July 25 to 26, 2007 stay at the West Chicago. Individual D's third polygraph examination was on July 26, 2007. Bank documents. Records from various financial institutions reflect the following payments in keeping with the allegations in the superseding indictment. A September 2008 Bass Productions check signed by McDavid to minor one's father in the amount of $30,000. A June 30th, 2009 wire payment from Bass Productions to pay individual B to settle a lawsuit in the amount of $125,000. And April 17, 2017, Bass Productions check in the amount of $200,000 to Brown, which was cashed the same day as noted above. Individual C and individual D each received $20,000 in cash on April 17, 2007, and $8,000 on April 20, 2007. Monthly payments from January 2014 to October 2015 from Kelly's business to minor one in the amount of $1,150. And August 2014 wire transfer from Kelly to McDavid in the amount of $80,000, and a December 2015 wire transfer from Kelly to McDavid in the amount of $10,000. Conspiratorial statements. The co-conspirators, in addition to the defendants as charged in the superseding indictment, include individuals A, B, C, and D. Individual A passed away after the relevant events in this case. individual D to the extent she was involved in securing, retrieving, and concealing the tapes depicting Kelly engaged in sexual activity was a co-conspirator of the other individuals involved in those activities, but individual D, with whom Kelly engaged in sexual activity right around the time individual D turned 18 years old, was also a victim of Kelly's conduct. Okay, so they explained the way that, yeah, she was a co-conspirator in all of that recoupment of those videotapes and all that, because she did have a hand in that. It also explained the way that she was also allegedly a victim of R. Kelly's sexual abuse. Okay, it says the statements between the co-conspirators and furtherance of the conspiracies involving obstruction of justice and receipt of child pornography fall into numerous categories concerning subjects integral to the conspiracies, actions in furtherance of the conspiracies, and to the success of the conspiracies. The statements are too voluminous to be listed in their entirety in this proffer. As a result, the nature of the statements are described by category below. This list provides an illustration of, but not an exhaustive description of, the nature of these statements. The statements of co-conspirators made in furtherance of the charged conspiracies include the following categories of statements. Statements made by individual A, B, C, and D to each other, to others, or in documents in the course of collecting and returning to the defendant videotapes depicting Kelly engaged in sexual acts with minors. These statements include, for example, those related to booking travel and making arrangements to meet with the defendants for the purpose of returning to the videotapes. Y'all listen as I read these. This is giving you an idea of what's on the goddamn statements. Lord have mercy. And who they all done talked to, and all of that. Number 2, statements made by individual A, B, C, and D to each other, to others, or in documents regarding payments received or owed to collect and return to defendants videotapes depicting Kelly engaged in sexual acts with minors, or to ensure that they would not cooperate with law enforcement or otherwise disclose information regarding such activity. Statements made by individual A, B, C, and D to each other, others, or in documents regarding polygraph examinations administered concerning individual B, C, and D's knowledge of or efforts to collect and return defendants' videotapes depicting Kelly engaged in sexual acts with minors. The statements proffered in the preceding section of this submission of individuals A, B, C, and D constitute co-conspirator statements under Rule 801 D2E because they are statements of co-conspirators in furtherance of the conspiracy. These statements, combined with the anticipated testimony of minors 1, 4, 5, and the other evidence set forth. Because remember, I told you, in order for these statements to get in, if they bring it in as co-conspirators exception, co-conspirators hearsay, it has to also have additional evidence to go along with this, right? To prove that a conspiracy existed. So here, this is what they're laying out. They're hammering it. They, bring it on home with this. So let me start. Okay, so these statements combined with the anticipated testimony of minors 1, 4, and 5, and the other evidence set forth above demonstrate the existence of conspiracy and defendants knowing participation in it and the acts they committed in furtherance of it. The statements of the defendants, to the extent that they are not otherwise admissions, constitute conspirator statements under Rule 801 D2E. The statements of individual A, B, C, and D fall squarely within Rule 801 D2E, and as well as the government's request that they be admitted on that basis. And it says this above is an outline of the evidence that the government will introduce to establish that the charged conspiracy existed based upon this proffer. The government respectfully requests that this government find that categories of conspiratorial statements listed above, as well as conspiratorial statements like them, are admissible pending the introduction of evidence to support this proffer. So what I said in the beginning and through this. So let me look at the read the footnotes. Let me find the footnotes. I saw a couple of them. Oh boy. Okay, this one. Number one. No Sixth Amendment confrontation issues. Remember, so that's the confrontation clause that I was telling you about. That will come up under Crawford and under the Bruton rule, right? That means that when you have the right to confront your accuser, right? But in the case when you have co-defendants, when they also have the right to, not plead the fifth or not take a stand or what have you, right? So that's when there may be a violation under that, especially when it comes to if it's under Crawford, that means that it could be like somebody made a statement that they're not there to be cross-examined. That may constitute a violation under Crawford. If it's a violation under the Bruton rule, that means that the co-defendants have made a statement that implicates one of those defendants, but they're not taking a stand. So look for that. Let's see. Okay, it says no Sixth Amendment confrontation issues are posed by the use of the non-testifying co-conspirators statement, meaning if they don't testify, they're saying that there's no issues based on for these statements. So these statements should be admissible because they don't see any confrontation clauses. They're trying to, and you see they tried to qualify their these statements to get in based on them saying these they disqualify under the co-conspirators hearsay, as well as they have additional evidence. That's why they laid out this entire document with all that information, damn near laying out the case to show that they got evidence to prove that there's a conspiracy. So the statements along with this conspiracy should be enough to get this admitted, these statements admitted. So let me see. It says the statements offered for the truth against the defendant, as such statements are non-testimonial, meaning and not testimonial. So not testimonial means that they are just supporting. Okay, when you see the word when it's testimonial, that means that it proves something. Okay, that means that it's a testimony that proves something. But when it's non-testimonial, it just supports evidence or fact in the case, right? So it says there's a whole bunch of case law, and then it said Second Circuit 2007 co-conspirator statements are neither hearsay nor testimonial. Okay, so meaning they should be admitted because it should be admitted because it'd be an exception, right? So it should be admitted. What's the next? Okay. Federal Rules of Evidence 801C defines hearsay as a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. So that means that statement, which in a statement could be in writing, it could be oral, or it could be like symbolic, like a head nod or whatever. But remember, when it's offered as hearsay, is evidence to prove the truth of the matter asserted in the statement, and the truth of the matter asserted in the statement must also match the facts. So if I have a statement saying that somebody said that I shot Johnny on Friday at 2 a.m., the facts in the case must also say that I shot Johnny at 2 a.m. on Friday. So that's what it means when the hearsay is admissible. Okay. Let me see. Okay, 3. The government has tendered to defendants all of the statements and reports of interview to date of the witness. What the fuck? Hold on, y'all. The records and other documents referenced in this section have been produced to defendants in discovery. So the defendant, so they have this in discovery. Okay. Okay. Minor one's passport was issued on about March 16, 1998, when she was 13 years old. Oh. Okay, as explained below, at this time, law enforcement was investigating Kelly regarding video 1. Okay. Okay, as noted above, individual B is expected to testify that he refused to sit for one polygraph examination despite the polygraphers being present. Okay, while these videos must remain in the custody of law enforcement, they have been made available to the defense for review. Okay, which what I explained to y'all. Okay, neither minor one nor minor one's mother recalls seeing Brown during their overseas travel. Okay, so they didn't see him. Well, okay, that might, Mary, you might have something there. They didn't see Brown, but they have where he was supposed to be there at the same time they were there. All right. As set forth above, a number of out of court statements from these sources would be admissible without regard to the conspirator hearsay rule, which is what I was telling you about, the conspirator hearsay rule, because they are statements of the defendants, statements not offered to prove the truth of the matter asserted for other reasons. Okay. The government is not detailing each and every proposed conspirator statement of each witness or document, but rather a representative sample of the statements from each witness and or the document. Further, by attributing statements to particular witnesses, the government is not committing to call each of the witnesses for each of the statements attributed. Of course, the government is committed to establishing the Borgiarelli predicates at trial and the ultimate admissibility, of co-conspirator statements is governed by the trial evidence. Okay, so that is it with that. Take that down. I'm coming back around the front. Mm, 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 mm. Well, hold on. Okay, people, listen. I would, and I'm not on no side. I ain't trying to be, no need to be. I ain't supporting nothing and nobody. Don't need to be, don't have to be. I can tell you this. I wouldn't wish this on either side. Because this is a lot. I wouldn't wish this shit on either side. You know, I ain't never even. I don't know. I'm just, woo. Y'all, give me a minute. Wait a minute. I mean, I can drop the link, but god damn. Hold on, let me drop this link. Yeah, that's pretty much, yeah. I really don't want to say that, but god damn. I wouldn't wish this on nobody. I mean, this is it's terrible on all sides, especially when you have all these factors and all of that stuff. It's just crazy. And it's a lot that went on here, right? You have these lawyers working overtime on both sides. It ain't just on one side, it's both sides. And I ain't no way in hell. Ain't no way in hell. I mean, shout out to, the people that support whatever side you support and how you get down and whatever. Shout outs to you, because that takes some kind of, I'm talking about the real ones now. I'm talking, because that takes some type of dedication and stuff like that, right? I feel like what I do is the easy part. I'm just breaking it down wherever it falls, that's where it goes, you know. But this is a lot. And so, but like I said, pretty much, and I dropped the link, but pretty much they are they're trying to jump ahead of, they're trying to shut down a lot of defenses, get a lot of stuff in. I mean, they jump into it before it even becomes a issue. Although Mary kind of kicked this up with the statements and everything because she saw it. But here's the thing, right? Wait a minute, I'm gonna make sure because I think I'm giving her the right credit. Hold on, I think it was Mary. Ain't this Mary? Hold on, because I think it was Mary. It was Mary. Mary is the one that caught all these statements. Yeah, she caught all these statements. And I ain't taking nothing from nobody, whatever. No, that's not what I'm doing. But she caught all these goddamn statements. And she tried to jump on it. Okay? Because McDavid and them, they arguing and shit. Mary the only one working. She caught it. She's like, hey. Anybody see all these statements in Discovery? Hey, y'all out here bullshit. Arguing back and forth. Talking about shit should be separate. Are y'all arguing all in court and all this here? And these people got these statements swimming all through the motherfucking goddamn Discovery. Shit. Mary is at work. Yeah. But she had to get down. She had to get down to it though. Because she seen that, listen, all these people, I mean, realize what this is. You already got people on the stand telling, talking. Now you got people with statements and shit talking. Everybody talking about something. Yeah, so that's just what it is. And they're like, hey, shit, the fuck? Ain't nobody working but me? The fuck is going on? God damn. Mm-mm-mm. Mm-mm-mm. But yes, but they trying to get around this. I don't know. J-Bo may well Mary probably come back and respond to. And hey, this should be off limits, and here's why. I don't know what other way they're gonna go. I mean, they're gonna have to respond that it got it's gonna violate the hearsay rule or the confrontation clause. I don't know other way they're gonna get around it or what other argument they can make. Mm, 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 mm. Yeah, they dropped the hell out them details. Oh, they dropped them. Yeah, we knows as hell. But listen, I wouldn't. Y'all got a hard job. What I do is easy, easy. I get in and get the fuck out. Yeah, that's what I'm saying. This was shit. He may luck up. He may luck up, and Leonard Weber may just if there is a conviction or whatever. I'm not saying it will be. I'm just saying he may run 30, concurrently. But he have to make an exception to do that. I mean, not accept. He got to make an exception. But that's what the word I'm using, because it usually would be you got to do. Um, it got to be consecutive, right? But and let me tell you this. This is almost a month out, right? And he's been held on these charges since 2019. I don't care what nobody tell y'all. Just listen to this. I said this a million times. Once you get an indictment in your office, and everybody go to look, you're gonna look for any attorney is gonna look for the easiest shit to get a case dismissed. Because the best way to beat a case is to get rid of it, right? So you're gonna look for statute of limitation issues, double jeopardy, violations, all kind of stuff. You're gonna look for that easy shit. That's the easy tap 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 on the keyboard, put some paperwork in, and get a motion on, right? That's easy. If they ain't caught it yet, if they ain't dropped it yet because of those reasons, that's because it was timely filed. There is no double jeopardy. This, that, and the third. I mean, all that's been ruled out. Okay, these people they got their pretrial motions going. They have pretrial motions going. If they was going to dismiss with back, they would have put in for some goddamn statute of limitations, double jeopardy, long before they was wrecking their motherfucking brains down here with this bullshit got to do with hearsay and the confrontation clause and motion to limit all of that. Why you gonna put the hardest shit out there first and then do the easiest. No. That's not how it works. That is not how it works. Uh-uh. They made sure that these charges can be levied against them, right? As well as it seems like they got more fucking. God damn, boy, them statements that took me out. I'm gonna tell you that. I'm just not getting it together. Them statements that took my ass out. I'm like, oh no, damn, it's a statement everywhere. And then they done messed up your boys because they ain't say. I ain't see nothing that McDavid was maybe going to pursue. Like I ain't know, I ain't know nothing who them how them girls are. I ain't know nothing about that. But we definitely did see that was Milton, right? I mean, of course they don't come out and say it, but that's just me deciphering, right? But they shut that down. And like you knew, or we think you knew, because it is. And they got Milton's hand in just like Mayor tried to say, like, okay, he just showed up, okay, on one occasion, maybe, and he didn't even know what he was doing there when he was there. They got him, they allegedly got him all like all with the other individuals and shit done seen. Yeah, see, when you have the shit like that, now you're getting into the weeds. Now it's getting like, okay, your involvement is a little bit more than what you said it was. Right. You think that I'm gonna be something talking about some bullshit on a case that could have been thrown out over some motherfucking double jeopardy? You think we'll be here today talking about some goddamn hearsay? I'm probably lost y'all ass and everything. Hey, all you need to know is, hell, they trying to get it in. They trying to get these statements in, and I told you reasons how they trying to get it in. And you see, I mean, that's why I talked about those things before Crawford even showed up in the paperwork, before Bruton even shows up, before issues with hearsay shows up, whatever, because this is what happens when you got co-defendants, aka co-conspirators. But this is the shit that comes about. Ah, yeah, this crazy. Y'all, I don't know. I wouldn't wish this on nobody. Uh-uh. Uh-uh. But as we see, as we see, so we see in Chicago case. Oh, I think pretty much in New York case it was okay, but Chicago case has been detailed because these motions, these filings that been coming out, they've been pretty good, right? Because they have, like I said, the mandatory law, primary law, case law. They have remedies and shit. Even we seen a case of evidence, right? That was with R. Kelly's declaration. That was evidence to support one of his motions, right? So we got some evidence in not really. Well, yeah, I can put in the category of evidence. In this motion, we got a lot of shit out of this. We got records. all kinds of shit. Ah, dang. Mary, I was rooting for you there, girl. Y'all ain't tell me we're gonna read this rough. Nobody ain't tell me about this. Damn. Oh man. Mm. Yeah, I'm about to get on up out of here. So y'all let me know. Are y'all thoroughly confused now, or do y'all understand what you're looking for? Y'all let me know. 'Cause I don't like to leave nobody confused there. Y'all know, do we know what they're trying to do? We always got to know what they're trying to do. Let me know. Y'all get it? They're trying to get it in. So remember. Oh, shit. So what we got to do is we got to see. I don't know how she gonna come back with this. I don't know how they gonna respond to this. Somehow, some kind of way, they got to come back and say that it violates these statements, if allowed in, violates their rights. Got to be some kind of way in that confrontation clause, and maybe they can take a shot at hearsay. That's on. I'm lost. That's the only way I think that they could try to respond to this. But I automatically think that because the government laid it out like they gave it more than what it needed. You know what I'm saying? To support that they have, along with these statements, they have other evidence that proves that there was some kind of conspiracy going on. I'm just thinking right now. Mm, 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 mm. Mm-hmm. Y'all, listen. I'm gonna push on out. I have a date with some sleep. Okay. Yeah, it was a lot, girl. It was a lot because they did more than enough to establish. And then they had a nerve to say that wasn't it. I'm like, well, that damn. But shouts out to Mayor who saw the motherfucking statements and shit, and no, she had to do something. Cause while everybody else arguing and fighting and shit and talking about the dead attorney and all this shit, Mary like, look, bitch, papers coming through. They got statements. Mm-mm-mm. I'm going to push out and let y'all have the remainder of y'all Saturday. Make sure y'all do this. Do all them things there for me. Just do all them things there. Yeah, Mary be on it. Oh, let me holler at some of y'all. I'm being so rude. Hey, Miss Karen. Hey, Mark Queen K. Hey, Mo. Hey, Miss Denise. Hey, Chi-Town OG. Shawty. The hell, what's good with it? Hey, Spam. Spam, hey, Love Spare. Remember, she tried to lie and say she wanted no damn relationship with R. Kelly. She lied. Hey, Star. Ooh, the spam, the spam. Hey, Danny. Hey, Danny. Hey, Danny. Hello, Danny. Hey, Purple Purple. Hey, Leslie Jennings. Hey, Peace and Serenity. Hey, Indy's Finest. 84. Michelle, that's it. That's old. Hey, Jennifer. Hey, Queen Everybody. Hey, Sophia. Something. Hey, Red. Red. Hey, Sonya Davis. Hey, Courtney Love. And anybody might catch me on the replay. Well, oh, Daddy low, low. Keep it low, Daddy. Yeah. With that being said, y'all, I am getting on up out of here. Y'all have to enjoy the rest of y'all weekend, honey. And I know telling when y'all see me again, baby. I am in training like I'm some kind of jit and shit. Mm-hmm. Yes, honey. Anyway, all right, y'all. I will see y'all, and I appreciate y'all for coming on through. I enjoy y'all. Love it. Even though I ain't had get a chance to interact with you too much, cause I had to read, honey. Had to read. But anyway, I'll see y'all again. There's another one in the books. Peace out.